Yeah,
Right, despite
powder
your
in
good
my
spot, you ready to
I
move on
have
to the next
like
area, or you have
powder
any more questions
That
about
would
this?
be
in my
500.
freezer, but
Cool, so why don't we
no, I'm not
take our
gonna use.
morning break, 15, 20 minutes?
So this
15,
should be
20
fun.
minutes. Bye, bitch. Get the fuck out. All right. This means fan content, which means we get the dinosaur content. Okay. All right. Here's the dinosaur content channel. The dinosaur content is going on the channel called Giggy. Here's the content. Like, let's have a look at the content. Okay.
Let's have a look at the content.
All right. This is the content you can expect from my new dinosaur channel. Press. It's not. My neighbors are mad. Can we?
This is why you never take the bait.
This is true. Don't take the bait. Don't take the bait, chat, on the aisle.
Meme is a funny guy.
This
Funny
is the
guy,
dinosaur.
chat.
Fucking hell. It's not working. Ooh. Yeah, I'm slosh. Okay. You worried about it? All right. This is good. This is a good video, though. This is a good video. It's got like 3,000 videos already.
We're doing A26.
Fuck.
And A26 is going to be...
What's the fan? What's the fucking fan for a second?
Is the letter P.
Fucking wankers.
So we gotta fill in all the letter P's.
Oh my goodness. I'm a big metal fan. Yeah, me too. Okay. What the fuck? Fuck off, Max. Max says if Josh plays a female dinosaur, that makes him a Tyrannosaurus. Look, playing female dinosaurs is actually kind of beneficial for many reasons. Fan death is a Korean thing, okay? That doesn't happen, okay? Fuck, why is this not working? Okay? We have no noises are working, but nothing else works.
I don't know if this might actually be better if I turn this off. That backlight thing.
This is not fair. Fuck you, Andrew.
I think you guys would see it better if I turn it off. So
my dinosaur channel actually has content. Okay, I already have people reviewing to me. Okay, it's not just fans and shit.
We've got some lighting challenges right now with this particular.
You guys don't even understand. You guys don't even understand. It's amazing to see someone this drunk on stream but still sitting upright. This is the content you won't get from a Nick. Okay. From a Nick. Okay. I am the most sober drunk law tuber. Okay.
Much better now.
I'm a non-practicing non-lawyer. Okay. But I drink more than they do. Because the lawyers, they be in no shit. Okay.
You're just a nerd.
Andrew's like, don't believe his fucking lies, okay? This is like fucking Nagini is telling you to like follow their posts or some shit. Like, don't believe Nagini's lies, okay? He's spending the Somali dollars, so he's got like $20,000 to spend on this stream, okay? Drop some fucking
one of the
big
places that I know that I can only put one in.
Anyway, the dinosaur channel is it's called Giggy Wig. Okay, I'm gonna drop a dinosaur video in the next couple of days. It's a pretty good 2 meter man. Okay. Oh, I can't. What the fuck? YouTube is fucking up right now. This is not fair. I'm gonna share my dinosaur videos with people.
It's not fair. It's the government's fault.
I want to show you my I actually have Croc Tent. That's the thing, is I'm so fucking mad because I have Croc Tent to share with you.
This is why you never.
All right,
take
there
the
we go.
bait
There we go.
on
There we
the
go.
eye.
There we go. We got the. This is my first video on my Croc Tent channel. This is a good
I
video.
didn't
This is a
even
good
have.
video.
Come on now.
Watch this.
I
This
didn't
is
even
why
have a
you never
dynamo.
take the bait on the aisle.
True and real. The fucking Carnotaurus, he's trying to trick me with his fucking crocodile.
Far away. I'm pretty sure I can get a bite in.
This is like a second croc, okay?
And there's two. Almost got me, but not today, you cheeky little pack mixers.
Fucking pack mixers. Am I right, chat? Okay. We can't watch this. This is actually hard away. This is actually a good video. Timu Attenborough? That's what I'm doing. It's not true. Woo! Alright. Anyway, continuing with Can Read. This is the thing, is that if you watch Can Read on the replay, you get to just skip past the fucking sidebars. This is why Kurt's content is better than everyone else's.
Ask you whether
It's not content, it's croc-tent. Okay? Like look at this.
This is why you.
So this fucking wanker. I was
Never
playing
take
my
the
Dilophosaur.
On the aisle.
And this fucking baby Carnotaurus tried to bait me. He tried to bait me into the water. I knew that was a fucking bait. I knew that was bait. Okay? It was one croc. I'm not gonna fall for this.
Far away. I'm pretty sure I can get a bite in.
Okay, there's two crocs.
Or at least two.
And there's
Second croc, he failed.
We've got two.
Fuck you, second croc.
two. Almost got me, but not today, you cheeky little pack mixers.
Unbelievable. Anyway. Let's continue with the Can Read, I guess. It's like a fan or some shit.
Let's see.
Oh my god, I'm a big metal fan. Yeah, me too. Let's go.
It's the Apple Health data, yes.
we asked about it, or I asked you about it earlier on, but I just want to talk about it a little bit before you show us and present to us the data that you've compiled for us. Is Apple Health data different than when you have like an Apple Watch?
No, it's the same Apple Health data recording on the phone or the watch. The only difference is the sensors being used to do that monitoring. So if you're just using the phone, obviously you're only using the sensors in the phone. It's limited to steps walked and to altitude climbed. If you're wearing a watch, it can also do those things, but it can also add things like blood pressure monitoring and things like that.
Does Apple Health data require an internet connection?
It doesn't, no.
So it's all self-survives on the phone itself?
It is.
So without having an internet connection, it will still store the data?
Correct.
If I have an iPhone, is it storing health data even if I didn't ask for it to do so?
Yes. Unless you actively turn the feature off, it will by default try to track movement.
Is it something that is hidden that I wouldn't see unless I look for it?
No, there's an application for Apple Health, and then the settings are quite obvious in the settings screen.
Apple Health data
Okay, we're just going to go
tracks
back
movement of the
to
phone?
do
Correct.
one at a time.
When you were considering the Apple Health data in this case, did you begin looking for the Apple Health data before Mr. O'Keefe's phone began approaching
It'll be
Fairview
easier.
Road?
Yeah, I started again at around midnight and looked at the health data up until 6:30 a.m. on the 29th.
The different points when you track Apple Health data,
You might need
is
more.
that helpful even if you're only trying to isolate a certain point in time?
It can be, yes.
Does it help determine whether or not it was working properly? If it was,
It can determine whether it's working properly. It can determine an average kind of walking speed, for example, of a person, the average gait that the person may walk with, if that was important.
if a person has an iPhone and they're moving and it registers Apple Health data, and then they stop moving, and the healthcare data doesn't register because there's no movement, would the Apple Health data resume movement even if somebody else picks up the phone?
It would. The phone itself doesn't care who's carrying it. It just looks for movement.
So it doesn't identify the owner in order to register movement?
Correct.
Does it identify the owner in order to register
Better
movement?
question.
It doesn't, no.
Could you turn to the next part of the data analysis that you did,
Yes.
please?
So the two sources that I got the Apple Health data from were a database called healthdb_secure.sqlite. This, as I said earlier, is the typical database that's used to store long-term information about the health activity that's been recorded. So this database can have years worth of steps taken, flights climbed, and any other kind of health data that's been recorded. The downside to that is that the information is aggregated. So you see chunks of time and multiple activities can happen within those chunks of time. The cache encrypted C .SQLite database is much more temporary, but is much more granular. So we can see exact times that flights were climbed, for example, or at least you can see the exact time that the flight climb was recorded to the device. And then that information is aggregated into the larger chunk of time.
Can we?
So again, we might see
can we
within the cache
increase
encrypted C
speed?
individual flight climb events that occurred.
This
For
is
example,
terrible.
the second
This
part.
sucks.
But
This
by the time
fucking
that information
sucks.
is written to the health DB secure, you're now looking at a 10-minute time period with 3 flight climb events, as opposed
Let's go
to
to
3
2
individual
point.
flight climb
Let's
events.
go to
with individual
2 point
timestamps.
speed.
Typically, that source is not used because the data is not stored there for very long. The information I found on John's phone was essentially these 5 records. So between 11 minutes and 9 seconds and 21 minutes and 5 seconds, there were 170 steps.
But we have an important chat. Okay, I saw him in the chat. Where is it?
Recorded by the device.
Mr. Whiffen, I'm going to stop at each one and ask you some questions. At the time period between 12:11:09, 12:21:05, you don't have any independent information where.
Big
John keeps his cell phone,
Chungus says.
The location data that I showed to begin.
Do you need to go to the bathroom for roughly 45 minutes? No, every 45 minutes is fine.
With on Washington Street was around 12 minutes after midnight. So the presumption is that's where the location was at that time. And then 21 minutes and 5 seconds, the device had already started using Waze. It was already driving along Denham Street or turned onto Maplecroft.
What time did you say that Waze was initiated?
You don't go to the bathroom enough, and you don't understand how streaming like Nick works.
Again, we see at 21 minutes and 10 seconds until 24 minutes and 22 seconds, there are 80 steps recorded.
You're
Again, if
not
you compare this to the location
properly
data, we know that the device
channeling
was
your
being
inner
recorded this
Nick. Sorry.
Between 22 minutes and 14 seconds and 24 minutes and 37 seconds, we have 3 flight climb events that are aggregated into that time period. And again, the location data shows that the device was traveling in the vehicle at that time.
Mr. Whiffen, you had showed us a slide of 24:37 on January 29, 2022 in your PowerPoint presentation, noting at that time, 12:24:37, the phone in the car was still traveling at 1.4 miles per hour.
Correct, this is about a second before it came to a stop.
Can you conclude to a reasonable degree of scientific certainty that that period of 12:22:14 to 12:24:37, Mr. O'Keefe, or at least Mr. O'Keefe's cell phone was still in that car?
Yes, the location data shows it was in the car at the time, and my next few slides will demonstrate why that was still recording a flight climb event while it was in the vehicle.
Thank you.
At 31 minutes and 56 seconds until 32 minutes and 16 seconds, there were 36 steps recorded. And then there was no further health activity recorded on the device for several hours until 4 minutes after 6 a.m. When 432 steps were recorded between the time of 6:04 and 6:11.
You know what's better watching this? Is watching the movie Ponyo. Ponyo is a really good movie and it has much better payoff than this fucking light expert, okay? Watch Ponyo. Ponyo is really good.
Let me ask you about that 12:31:56 to 12:32:16 time period. We can see larger ranges in the time period range. That is a smaller range comparatively.
Yes.
Okay. At 12:31:56, is that the beginning of the 36 steps?
Essentially, yeah, it takes the timestamps from the cache encrypted C, looks at when the first step occurred, looks at when the last step occurred, and aggregates the times based on that.
So 12:32:16 would be the last steps taken for that cell phone.
Correct.
And in between that time period, there's 36 steps you shared earlier that it doesn't indicate the direction of the steps. Other than the movement that equates the steps, can it tell anything about what direction, the positioning, how the phone was moving?
It can't, no. It's just purely registered what it thinks are 36 steps.
Could it have been a straight line?
It could have been
Could
straight.
it have been somebody pacing?
It could have been.
Could it have been somebody moving and jumping?
Yes. Jumping, if they were jumping forward, essentially.
After 12:32:16, when this phone took its last steps, it never moved again?
What were the questions, Sustained?
After 12:32:16, when this phone took its last steps, did it move again until 6:04 or 1 a.m.?
There were no more steps or flight climb or any other health activity recorded during that time.
Do you know what triggered movement at 6:04 or 1 a.m. of Mr. O'Keefe's cell phone?
I presume that the device was moving at that time, but I don't know the details of who.
Oh my fucking god.
Please continue.
Can we just
regarding the
get,
flight climb events,
Chat.
looking at the cache encrypted C data,
do we just skip past the guy's content? Post a 1 in the chat if you want to skip past this guy. This guy sucks.
database, I was able to find more granular, accurate timestamps for these records. And I showed those timestamps on this map at the position that the device was, according to the location data at the time.
So you're going
Since
back
trial
to the event now,
content.
12:22:14
Correct.
to 12:24:37 when the phone stopped.
Cool,
the other flight.
did it.
Thank you.
So we have the first record at 22:17.
That's
flight plan
not
event recorded.
easy,
I highlighted that was a
but
red line. That equates to
did
the red line
it.
shows the timestamp where the
Stop.
location was.
Stop.
Where the device was
Fuck
at that
off,
time.
chat.
The second record is 22 minutes and 32 seconds, showed with a green line, which shows over here. And then finally, 24 minutes and 37 seconds after midnight, shows with an orange line down here outside 34:30. I'd like to point out that health activity events are recorded upon the event completion. The device doesn't know that you're about to walk up some stairs. It doesn't know that you're halfway up some stairs. It has to wait until you reach the top in order to detect that an altitude change has occurred. So that change only gets written to the database once the flight climb has ended. I tested approximately 8 different phones, different models, different versions of iOS, and found that on average there was a time difference between 15 and 50 seconds between when I physically stopped walking up a flight of stairs and when the record was made. So it's just based on the time that the device takes to pull the altitude, detect that an altitude difference has occurred, and then write the data to the database. So I took that average data between 15 and 50 seconds and plotted it onto this graph, which also plots the altitude of the device over time. So the red line here shows the time according to the cache encrypted C database where the first flight climb event was recorded at 22 minutes and 17 seconds. Working back 15 seconds from that to say that with the gap that I know exists between the flight climb ending and when the record was recorded, the flight climb event is presumed to have occurred within this red gradient area. The altitude information on the device shows that between those times, the altitude increased from around 41 meters to around 45 meters. You may recall earlier I said that it's a 3-meter incline that Apple considers a flight climb event. Therefore, the incline that occurred within this red gradient is sufficient to trip a flight climb event. When we look at the second record at 22 minutes and 32 seconds, this is shown on this chart as a green line, and again, working back 15 seconds and beyond to allow for the tolerance, we see the green gradient area. This shows an altitude change of around 45 meters to 48 meters.
It's a green gradient, chat.
For a flight climb event to be recorded because we have 3-meter incline change. We then don't see an incline change for a while. All we see is the device going downhill until we get the record right at the end there at 24 minutes and 37 seconds. And again, working back around 15 seconds to the orange gradient, we see an increase from around 25 to 28, 29 meters. Again, that would be sufficient to cause a flight climb event to be recorded.
Like, actually,
Sorry.
continue, and then I'll ask you, please.
I then compared that information to a topology website from the area, according to topology website data, and plotted that out here. We see the red circle now is related to the first flight climb, the green circle to the second flight climb, and the orange circle to the third flight climb. The gradients that we see here are the same gradients that were shown on the previous graph. So the presumption is that within this red gradient is where the flight climb event occurred. Within the green gradient here is where the second flight climb event occurred, and within the orange gradient here is where the third flight climb event occurred. The white circles show the altitude of that particular location according to the topology website. So again, we see that for the red gradient, there's an increase from 43 to 47 meters. Between the green gradient and the green number 2, again, we're going from around 47 to 50 meters. And then with the orange gradient at the bottom, we've gone from around 26 to 28 meters. So fairly consistent with the data that was recorded on the device in terms of altitude information. And I would suggest is the reason that these flight climb events occurred.
Mr. Whiffen, there's 3 different times. The first is 12/22/17. At that time, was the Waze data app initiated?
It was.
And did that indicate whether or not Mr. O'Keefe or his phone were traveling in a car at that time?
Appeared to be still traveling in a car.
At 12/22/32, was the Waze data initiated and active?
It was, yes.
And at that time, does the data indicate that Mr. O'Keefe's phone was in a vehicle and moving?
It does.
And you showed us a slide finally from 12/24/37 that the vehicle was still moving 1.4 miles per hour.
Correct.
And was the Waze data initiated and active at that time, 12/24/37?
If I remember correctly, Waze had closed about 5 or 10 seconds earlier.
Now, based on your study of the Waze information, the location information, the topography, and the healthcare data, do you have an opinion to a reasonable degree of scientific certainty whether the indication on the healthcare data reflecting flights of stairs, do you have an opinion whether or not that was registered as a result of a person holding a phone walking upstairs or for some other reason?
Based on the location data, the health data, and the research that I did in the testing, I believe it is more likely that the device was in a vehicle traveling on a road going up an incline versus the location data being incorrect and the person being walking up physical stairs.
Thank you.
This fucking brutal. Like, what the fuck?
So I'll address
Tell
the idea of
me!
clocks.
I do want to die.
Why don't we just
No, no, this is not okay.
Oh my goodness.
That is kind of covered in the next slide. Okay, maybe worth just jumping ahead to that slide.
Explain the idea of 3 clocks.
Yes.
You're being a
essentially
little
there's one
bit
clock on an
absurd.
iPhone. It's the clock that you see. It's shown in the top corner, and all
But if
activity
you
is
are
related to that particular time. So when you receive
mocking
text
Nick
message,
here.
the time that's shown in the database is related to the time that you can see on the phone. When you do health activity, it's related to the time that you see in the top corner of the phone. Everything's related to that time.
No,
the
wait.
difference is within the current
This
power
is
log.
not
It's a
ending.
subset of files. stored
Stop.
on devices.
It's never
the
going to
default
end.
Crashing
It's not
out,
a
yes.
clock that can actually be trusted to see when events occurred. It's the way that the device records time. It's essentially a counter.
Okay,
It's just
we're
counting seconds
all
since the
blurry.
device
Like
was
the
set,
bottle?
basically. And I'm sure most
Why
people
are we blurry?
can recall a time
Can
where
I end
you
the
set a
stream
clock
if
on
I,
your digital
if I
device.
like the ball? Can I
After
like
3 or 4
can
months
I
later,
end
the clock's
it?
now not quite as
Yeah, we're
accurate. It
doing
wasn't.
fine.
Time starts to drift. It
Now
might
we're
drift forward and be
blurry.
faster. It might drift slower and be further behind. That essentially happens with the monotonic clock as well. So you have to take the values that the monotonic clock provides and add or subtract different values, which are essentially offsets, in order to get the accurate time. And that's what I'll be displaying in
That
this slide here.
fucking sucks.
The confusion with the idea of 3 clocks, I believe, comes from the way that
I'm sorry.
Magnet
We're
Axiom product
we're
displays
skipping.
power log
We're
data.
skipping this.
They show
boy.
a monotonic date and time, a base band date and time, and a display date and time within the power log records. As an examiner, it's really good to see this data and understand how the tool is determining these values.
I'm sorry. Like, no. This is exactly what it's. I can't stand this guy. Like, no. This is not happening. Okay, we're skipping him. We're skipping him. We don't give a shit about the iPhone expert. Okay, we're like onto like this fucking thing. Okay,
I don't know why we're blurry.
wait, is this the end of the stream? Maybe.
We were doing fine,
Well,
and now
thank
we're
fucking
blurry.
God. Holy shit. I don't have any lighters. I don't smoke. Holy shit, that was brutal. Oh my goodness. Kill me. What the fuck? Like,
Okay, that's better.
people are watching like a fucking metal fan for like an hour? I don't understand. Chat, please respond. Is this what Lord Sheepers actually do? Holy fucking Christ. Do you want to see more Can Read? Post a like in the chat or like the video, I guess. I'm gonna go to bed. This fucking sucks. LawTube content fucking sucks. I'm gonna say it. Okay, this is bullshit. This is bullshit. I would, if I had a lighter, I would fucking flame my nipple right now just to go to bed. It's better to go to bed with a burnt nipple than watching 4 hours of this content. Holy shit. Oh my goodness. People make money doing this? How fucking easy is their job? Oh my god. Oh my fucking god. Do you think, like, post one in the chat, do you think Nick can do 8 hours? He can do 8 hours for 8 weeks of this every fucking day? I did this for like 2 hours. I can't stand it. I'm sorry. I'm spent. I cannot do Karen Read for more than 2 hours, and this is the best thing I can do. I can't do it, chat. I can't do it. This is insane. I dropped in total, like, look at this. This is full when we started. I have like a shot left. Okay, I would rather drink this than do more Karen Read. Holy shit, so fucking boring. Do the shot? No, it's not gonna happen. It's not gonna happen. Okay. Lol. Do it now, sober. No, fuck you. I'm gonna go to bed. Do you know how good it feels to go to bed and wake up at like 8 a.m. and then you just like spend 2 hours playing the fish live stream thing? Okay. Look, the fish, they're not gonna make it with my help. I have to help them. I have to help. Oh fucking hell. This is so bad. Nick has, and the thing is, Nick has to do this for 5 years. I couldn't do it for one day. He has to do that. He has to do this for 5 years. He has to be a good boy. 5 years. This is so fucking boring. The only reason I can't do this is because of whiskey. Thank you, blessed. Oh my god, my camera turned off. Okay. We're actually on camera unreveal mode. Okay.
I can't. Part of the challenge with him right now is I can't tell if he's being facetious because he's just trying to do his inner Nick, or what. If he's being serious about it being like hard. He might just be doing his inner Nick, which is fine.
Files store. order to see this data and understand how the tool is determining these values. As an examiner, it would be really bad to look at these values and think that they are accurate timestamps at face value, because they aren't. And I'll start to talk through how this information works. So the other thing that Axiom shows, as well as the monotonic baseband and display times, is they show the location where this information came from. In this case, we have two tables. One is called PL Springboard Agent Event Forward S Block. And that is what this table is here. And you can see we've got an ID number, a timestamp, and a value of locked. But we also show a second table that's involved called PL Storage Operator Event Forward Time Offset. And that's this table at the bottom here. So again, we see there's an ID, a timestamp, baseband, kernel, and system values. These values all need to be read together in order to make sense of the data. So for example, if I take the timestamp that's shown here, the 1643 33687 number, if you treat that as number of seconds since the 1st of January 1970, it's what we call a Unix epoch. That will get you the timestamp of 29th of January 2022 at midnight, 21 minutes and 27 seconds.
Very quickly, huge thank you to Mr. Bubbles, gifted 1 Danny on direct membership. Everybody say thank you, Mr. Bubbles. Thank you, Mr. Bubbles. I bless you with no cat fur all over your suit when you need it to be clean.
Once you account for the UTC -5.
How did I get here?
And you'll see that that is the same timestamp that Axiom shows here as the monotonic time, 12:21:27. What we need to then do is
Did
take that
he
monotonic time,
switch
add
to-
it to the baseband value that
Or
we
did
see
something
in the
get
time
bumped
offset
on my
table.
end?
So now we have a value of 1643, 3687.14954,
Still on mean?
and we add minus
Nope, I am not on mean go
183
game anymore.
whatever this number is here, to get this value. If we treat this value as number of seconds since the 1st of January 1970, then we get a time of 18 minutes and 23 seconds past midnight on January 29th, which is also the time that we show here.
I don't
as the
know if
baseband
it's
time.
I didn't recall him saying that he was stopping.
Finally, we can take the monotonic time and add the minus 181 seconds shown in the system to get this value, which equates to 18 minutes and 25 seconds past midnight on the 29th of January, which is the same as the display time up here. So all this is essentially doing is saying that the counter that is built into the iPhone.
Well, I guess he's done. Well, that sucks. I'm gonna see what else it might be out there. Oh, there's some kind of blackout in Portugal, apparently. Let's see what Andrea Burkhardt has to say about everything. Apparently, the court is technically on break. Okay, I'm having problems here. Okay, this making sure that this is on the right side up. Yep, I've got one that's wrong. You gotta be careful about this because it's not easy to get it back, to get it, take it off, and then put it back on. Okay. Hoping that I don't have too many instances here where that happens. Okay, I'll be right back because I need something to eat as well. So 1, 2, 3, 4. Let's see if we can get 4 on here. Oops. And I've knocked them everywhere. It's not good. So we've got 4. And what's the exact number that I'm gonna need? Let's count it. 1, 2, 3, 4. Not bad, not bad. Not bad. Not bad. Yeah. That's upside down. I think. God, it's hard to see. Jesus. Yeah, it was upside down. Don't know how it ended up upside down, but it ended up upside down. I think that equal sign is a color that I have not opened yet. Yeah, do I have that open yet? I do have that. That might be the one that we want to start on next. I don't know. I think the piece that I have on here now is designed to pick up like 6 or something like that. And we just don't want that many. I'm gonna put this. Up to. Let's get this right here. See, now we can cover this up because we don't need to put anything on it. And we can kind of protect it a little bit. My food should be done. Or at the very least, I need to check it.
All right, guys. Back in just under the wire, but no court yet, so no rush. Wasn't super expecting it. Very glad I did go out and check the trees. Yeah, they are getting pretty dry. I watered them before I came on stream this morning, so that should tell you a little bit about how windy it is. Yeah, I can't read my weather station from here, but it's one of the reasons why I have it. So I can track what the wind's like. So a little bit of news came in. Saw a couple things during the break. First off, I did see. Adjust my chair here. Karen Reed's cert petition to the U.S. Supreme Court was denied. That does not come as any kind of major surprise to me. It was, that was the odds on pick for what was going to happen here. Even in the best case scenario, the U.S. Supreme Court accepts about 1% of all cert petitions that are filed in the court. They typically have certain criteria for the types of cases that they're looking for. Hers really didn't squarely fit within that. So it was always going to be a long shot. And then once they denied the stay as well, pretty good indication that they do not, have a overwhelmingly favorable view of the merits of the case when it comes to her position. So that happened. And that part of the case is now over. Double jeopardy issue is resolved. Not finding any problem with that last trial and everything that kind of went down in the background there. Other thing I saw is that apparently the juror that was being questioned at sidebar is not being excused. So whatever that was about, don't know. Looks like it's been addressed. And oh, yeah, I saw Turtle Boys announcing that Jen McCabe is tomorrow. So boy, we got a lot of excitement in short order, don't we? We got Crash Daddies this afternoon, and then Jen McCabe tomorrow. A lot of stuff happening in a short period of time in this case. If that's the situation. Turtle Boy was getting information at the last trial about the order in which witnesses were being called. He was very accurate with his information, so don't have any reason to suspect that he's wrong this time. So if that's the case, Jen McCabe as soon as we wrap up with Ian Whiffen. So they're going to debunk Hosselong to Dying Cold, and then immediately put Jen on to kind of reiterate that and to officially deny it. But what's she going to do with these issues with the timeline? That's going to be the $1 million question.
Yep.
That's going to be the $1 million question. I had something pop up in my mind while we were looking at the location data. I just wanted to double check. So it's after 12:59 that the accuracy is bad. It's all over 1 to 2 a.m. It's still bad. The best ones are 25 meters or better. 2 to 3 a.m. They're just kind of all over the place. What's causing the phone to seek the location data at this time? We don't have apps running. I mean, I don't know. I don't know that necessarily means anything or doesn't. But it's just something that kind of stands out to me. Why did the phone suddenly go to low accuracy at a time when the phone is not supposed to be in use? And then it's just kind of off and on over the course of the day or over the course of the morning, very early morning reporting location. I don't know. I would expect something triggers it, but what triggered it, I don't know. So just something that I thought of while we were waiting and wanted to follow up on. Let's get back to some of your questions and comments. Beach Rando. I'm the step queen, and stairs while driven doesn't happen. Ask anyone in a step challenge if there is a way to cheat. We would have found it. I've heard this many times. I've heard a lot of anecdotal stories about people trying to recreate this version of the driving up a hill causing flights to register, and it doesn't happen. I have yet to hear of somebody besides Ian Whiffen reportedly being able to successfully recreate this. I'd like to see it. I'm intrigued by it. This came up in Delphi as well because they had an issue with steps and flights climbed, elevation measurements and movements and stuff that didn't necessarily fit within the state's theory of how that crime was committed. And yeah, stuff comes up pretty often, and most of the time the experts tell us the health data is pretty reliable. It's not necessarily all that precise. You know, there's a lot of averages when it comes to measuring steps and things like that. It's assuming constants, right? It's assuming your tread, the width of your step is pretty constant. Your pace is constant and so forth when you're covering distance over time. So it's not necessarily going to record like if you're suddenly taking very short steps. It's not necessarily going to accurately update. Here's what the exact distance covered was, because it's relying on assumptions. So it's not necessarily that precise when it comes to what it reports. But the general consensus is that it's pretty reliable, and certainly law enforcement often treats it like it's highly reliable. Apparently, until they don't want it to be highly reliable, then it's not. Kim Neighbor, Andrea, can you recap how his testimony conflicts with the butt dial explanations? I didn't follow. Well, it doesn't conflict with the butt dial explanations, but it's given us a preview. It's given us a preview of something to look forward to with Jen McCabe, because what he's told us is that when a call is received, the phone, or when a call is received to the phone will attempt to find a person. It will attempt to find a face when there's activity going on in the phone. And so they have Jen McCabe's cell phone. They have her extraction, and her explanation to all of these phone calls to John between 12:30 something to 12:40 something, like after her timeline got busted, is that those were butt dials. And it sounds like from Mr. Whiffen, they're going to be able to look at the phone data and verify if that's the case or not, because they're going to be able to see, was the phone in her pocket? What was the phone state at the time? What was the phone state at the time? We'll see. We'll see how that pans out. We don't have anybody else's phone extraction other than Carrie Roberts's, as far as I know. So we can't check the Higgins and Brian Albert, right? They got rid of their phones the day before the preservation order was signed. So we can't check their phones. We don't have an extraction. Don't believe we had one for Nicole Albert, who was one of the other butt dialers. It's just going to go to Jen McCabe and her explanation that all of those phone calls with John O'Keefe, those were butt dials. I believe there might also be a record of a phone call she made to Nicole in the morning, like when they first got to the scene. We'll have to see when the phone records come up. Oh, it looks like we're back. Let me get it back on. Got it paused real quick here.
Compel reciprocal discovery.
Let me back up.
reciprocal discovery regarding the ARCA witnesses. Previously, about a month or so ago, maybe longer,
Oops. Guys, my bad. I can't.
I found that there was a violation of the defendant's obligations for reciprocal discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCA witnesses or to exclude their testimonies. Upon that, I believe I issued an order last week for certain discovery to be provided and to be provided by ARCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them back, but I expect we can get through them. So Mr. Brennan, who are we going with first? Dr. Wolf?
Please.
And now it's in
Okay.
Mr. Brennan's court.
Okay, set. You're going to face the clerk and raise your right hand.
Solemnly swear that the testimony you shall give to the court in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
We are off the lunch break.
All right, go right ahead, Mr.
Thank you. Good afternoon, Doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So
order?
we need Dr. Wolf to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolf, last name spelled W-O-L-F-E.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Oh, Lord.
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay, did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Ms. Little, last year I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. That was, I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
It would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Miss Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Back in March of 2024, you spoke on the phone to Mr. Jackson?
Yes, sir.
A number of times?
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial, yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case, yes.
Did you speak to Miss Little by phone?
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please.
Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Miss Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? Do you have a Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Oh, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So, are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why wasn't you talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, Why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process when a client reaches out and wants to engage us for trial testimony. That's typically, again, the procedure that we prescribe at ARCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you on March 20th, 2022, not
He's
the
already
22nd,
answered
not
that.
the 24th. March 20th, 2024. Did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed. And I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should, please.
So when did you become an advocate for the defense?
Exchange.
Do you feel like you're an advocate for the defense?
No, sir.
You sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring to?
Do you remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCA was as a whole. I think we even got stuck a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started billing. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson. Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes. Specifically what they were to. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
No. Sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCA.
Well, this is a new relationship. You were working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April still?
Yeah, I'm still talking at April. April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of me.
Are you just making that up, or that's what happened?
Sir,
I just told you it's what it sounds
that is
like.
my best guess. I don't recall from a year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
Do you recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24th, 2024? Do you remember those 2 phone calls?
Objection, Your Honor.
So let's get an answer.
I don't remember those phone calls specifically, no, sir.
Next
Do
question.
you remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCA, but never ever talked about this case.
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCA. That doesn't come back to Dan Wolf.
Okay. So in order to get paid for that, you would have had to submit that time through ARCA to then forward it, wouldn't you?
Objection, Your Honor.
Going to allow it. Is that true?
Yes. I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Your Honor, can we get a vote, please?
Who asked me that?
Me, Your Honor.
Yes. Come on over.
Well, how come we're not getting any chastising of Mr. Brennan about how the commentary, the little snide little asides are not necessary? You know, the defense doesn't get to editorialize about the testimony, but here is Mr. Brennan. Oh yes, you certainly are on the side of the science, aren't you? He's getting to add his little snarky little takes here. My view is that Mr. Wolf is holding up on this very well. Mr. Brennan is badgering him. His questions are harassing. He keeps asking the same thing over and over again, then circles back and asks it another time. Mr. Alessi is objecting appropriately. He could be objecting more from my perspective. There's a lot of asked and answered stuff. He said, like a long time ago, he doesn't remember the two phone calls, the after phone calls that were made on April 24th. We went around it and around it and around it over and over again. What it could be is possible explanation for it. And then we come back to, you don't remember. Yes, we already know he doesn't remember because that's what he told you in the first place. So nobody's having difficulty understanding what the witness is saying besides Mr. Brennan. And he's only having difficulty because he doesn't want to hear it. He wants to try to push a different answer that is far more incriminating than, these guys called and probably talked to the receptionist. I don't have a receptionist now, but back when I did, if somebody calls the receptionist, they call the main line and the receptionist wants me on the phone, it's going to take probably about that time for her to find me, everything get transferred and so forth. If I'm not there, she's going to say not available, call back, leave a message, and I leave a message, whatever.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Now, when
did you at the
billed,
time?
Did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCA, talking about your families?
Yes.
Right. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay.
Objection, Your Honor.
Yeah.
No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
Mm-hmm. And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring to?
No, I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you're friends. I said, did you become friendly?
I talked to him like I talk to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
Yeah. So, do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
And by the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets, and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all of the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here? I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
Oh, you didn't tell me, but you just did now. Thank you.
Yeah, he did multiple times.
So next question, no
Okay.
comments, Mr. Boyd.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the numbers?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was it 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial. So.
Where were you when you were deleting these texts? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
Befuddled.
I have no idea, sir.
You can't remember deleting over 100 texts?
Sir,
no, because it's
I just said I delete
you.
texts routinely. You're asking me to specifically give you a location at a time when I deleted those? I don't recall that.
You said it was after the trial.
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like Signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
It's an encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career as when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr.
download.
Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard. Is it your standard to use an encrypted app when you're talking to attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations do you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. If you don't know, you don't know. How many times did you use Signal with the defense to talk about this case?
I'm going to allow it.
From what I recall, it was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
And he's telling you he doesn't
I'm telling
remember.
you that I didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means.
Probably around probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal? The 4 to 5 times?
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Are you
yes.
putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Objection, Your Honor.
Can you answer that? How confident are you, Dr.
I can't answer that anymore.
Okay.
When
Next
you were
question.
required by court order to provide all of the records to Your Honor, you knew that one of the important things you need to respond to were communications between you and the defense for Her Honor to consider, right?
Yes.
Okay. And Signal is a communication, isn't it?
Certainly.
You looked at all your records and knew it listed the text messages and the phone calls. You knew that, right?
Yes.
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
Yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your Signal calls were communications, didn't you?
But he has
I
no
provide
record.
everything that I had in my possession, sir.
That's not what I'm asking you. You knew the Signal calls were communications, didn't you?
Yes.
Okay. And you never informed in your response that they were phone calls through Signal
He wasn't
as part of
asked.
your communications,
It wasn't
did you?
interrogatory.
Again, because I didn't have any record like I do with the Verizon entries as well as the emails. I could not, there's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
During those 4 to 5 Signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these Signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there
trial.
wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the costs of you coming out here?
Yeah, no contract.
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill. I'm not.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. So did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Well, without qualification, the simple question is, you've met Kat, haven't you?
I think I met her. It was either at the voir dire day or the trial day, yes.
Mm-hmm. Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? Well, how was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked me back to the lot.
Did you have conversations with anybody for the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
Objection, Your Honor.
I'll allow it.
It's a pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in for voir dire or came in for trial? You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face,
Yes.
right? Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. He would give me some information about the scheduling and kind of when we would be needed. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there was kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. I can certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there, but there's a lot more communications before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
So you check in with a client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
Showing you an email. Do you recognize that?
Yes.
From you to who?
To Mr. Jackson.
Okay. And what's it labeled as?
Wolf Direct.
And that's before you testified on trial, 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified?
Yes.
Okay. Let me show you this document. Do you recognize that one?
Yes.
What's that?
That is the attachment to the email.
Okay. You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers to ask you when you testify.
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
There's an email with a document I'd like to attach this as an exhibit.
Okay. Exhibit 1. Exhibit 1.
So you assisted the defense before your testimony.
Hold on.
Of course, he prepped himself for it. He's not going to just show up and be like, I don't remember what we're here to talk about. The guy's a pro.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question.
Hold the comments, please.
My question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful?
Sustained.
Do you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
Objection, Your Honor.
All right, no comments, please.
Do you think
Fourth time with the no comments, and he
a
just
direct
ignores her.
examination to the defense
Shit.
before you
Screwed up.
testified is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized this, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question?
Objection, Your Honor.
Did you ever make any comments or discuss the outline that you provided to the defense to help better the testimony for the defense?
I did put comments, yes.
When I just showed you that document and you said you just sent it because this is a standard thing, why didn't you just tell us that you made comments that would assist the defense? Why didn't you share that when I just asked the question?
I don't understand your
You
question.
don't understand my question. I asked you about the outline, the direct examination you provided to the defense, and you gave me a response that this is something typical, but it's just an outline. You wouldn't answer whether it would help the defense or not, but the reality is you were assisting the defense, isn't it?
Objection, Your
I'm
Honor.
going to allow that.
You were making suggestions to help the defense, weren't you?
Sir, it wasn't to help the defense. It wasn't to help anyone but the jury understand things. As I just mentioned, that outline, if it was asked if I had sent one to the Commonwealth, you would have gotten the exact same copy.
You didn't send one to the Commonwealth.
The Commonwealth never reached out to us, sir.
So what you said in this is there was a question about, so not being able to inspect the vehicle is something that is not uncommon in your line of work, and you wrote back, absolutely not, correct?
Correct.
And you made a comment to assist the jury, according to you, only to assist the jury. Not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show jury it doesn't matter in this case. Were those your comments to the defense before your testimony?
Absolutely. And it would have been the same argument probably from the defense if you had called me a witness about not being able to inspect the vehicle. I wanted the jury to have an understand that for the analysis I undertook, it did not matter that I did not physically inspect the vehicle, sir.
So when you're telling us here under oath before this court that you did nothing to assist the defense, you do not think that you making these suggestions on how to better the testimony for the defense, you don't think that's helping the defense?
No.
Okay. You said not sure if you want to put this somewhere in the direct examination. So you're making suggestions to the defense about what you think could be helpful in the direct examination, correct?
So there were never any conversations between me and Mr. Jackson about what questions to ask, what not to ask. Again, I prepared that internally on my behalf and sent that to him. Whether he utilized it or not, I have no idea.
Not my question. Not my question. What I'm asking you is when you wrote to the defense and said, not sure if you want to put this somewhere in the direct examination.
Yes, slow down.
Sorry. When you wrote and offered, unsolicited according to you, to the defense, not sure if you want to put this somewhere in the direct examination, weren't you trying to help, sir?
I don't believe so, no, sir.
And then when you wrote, I have a feeling they are going to argue, I didn't personally inspect the vehicles. Who's they?
Well, it would have been the prosecution in this case.
But you're not taking sides, you're totally objective, right?
Sir, that is a question that's routinely raised when I testify about whether or not we inspected the vehicle. So I know it would be a potential issue that would be raised by either side.
So you were alerting the defense that you thought that this may become an issue, weren't you?
It was more or less to make sure the jury had an understanding that because I didn't physically inspect the vehicle, it did not matter for my analysis, sir. I wanted to make sure the jury understood that.
Don't hide behind the jury. I'm talking about your communications with the defense. I'm asking you specifically about your conversations with the defense.
That's two questions.
Get a hold of the courtroom.
You wrote, I have a feeling they are going to argue I didn't personally inspect the vehicles. That's what you wrote, correct?
Objection, Your Honor. The tone in the argumentation.
Did you write that?
Yes.
Right. And when you said they, you're referring to the opposition, the Commonwealth, correct?
Correct.
Right.
No control over her
you
courtroom.
offer an explanation or a way to deal with what the
She's not trying
Commonwealth
to,
may
lady.
confront you with,
That's
don't
the
you?
problem.
You make a suggestion
She's
to
not
help the
trying to
defense,
control
don't
it.
you?
She doesn't want
Again,
to.
it was to help the jury understand that
Unfortunately.
because I did not physically inspect the vehicle, it did not matter for my analysis. That was the point I was trying to make.
I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. That's what you wrote.
Right. Need to show the jury. Yeah. That's what I was trying to make sure that that point was understood to the jury.
In your collaboration with the defense, that's not all you wrote, is it? You gave them discretion about things that you should or shouldn't say in front of that jury who you say you want to hear everything. Didn't you?
There were other comments, yes.
If you want the jury to hear everything, you wouldn't be relying on the defense to tell you what to say and not say, would you?
I don't know if I understand your question.
Okay, you'll understand if I read this. Number 19. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? You remember that one?
Yes.
And then you wrote back, yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Remember that?
Yes.
Statistically speaking, most pedestrian fatalities occur during the evening and night hours. You remember that?
Yes, sir.
So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Yes?
Yes.
Okay. And then do you defer to the defense, not the jury, trying to give the full story to the jury? Do you defer to the defense in exercising discretion on what you will or will not say to the jury back then?
Well, allow me to explain, if you will.
I'm asking you a question.
Well, let me explain.
No, I'm asking you, did you defer?
Answer the question first.
Did you defer to the defense on what information they wanted you to put in front of that last jury or not?
I didn't defer to them. The reason for that comment is a few reasons, sir.
Let me read it and then you can give any explanation you want.
Hold on. Question, Mr. Brennan,
You
and
said-
then you answer, Dr. Wolf.
You said, if you don't want me to say this, that's fine. Are those your words?
Yes. Allow me to explain. Because for one, I want the jury to have an understanding, again, the jury to have an understanding of my background in lighting and human factors and how it relates to me seeing a lot of pedestrian impacts, right? So I want them to have that understanding. At the same time, I don't want them to get caught up in a statistic that just because there's more pedestrian impacts at night, that this alleged incident must have occurred because of that statistic.
Question 31. Have you been qualified as an expert in court before? And you wrote back, yes. Remember that?
Yes.
And then you made another comment. Do you remember that?
Yes.
I realized in my testimony, I said about 20 times when you asked how many times I've been qualified. You were referring to your voir dire testimony, correct?
Correct.
I misinterpreted your questions, which was my fault, but in looking at my D&T lists, it's 11 trials and 7 depositions, 18 testimonies total, correct?
Correct.
Not sure if you want me to clear this up or just leave it. Wouldn't you want to clear up a misstatement when you realize you had made a mistake? Wouldn't you want to inform the court, I stated qualifications I didn't have, it was unintentional, but it was a mistake?
Well, that's exactly why I put the comment in there, sir.
You put the comment, you didn't put the comment to the Commonwealth, did you?
Again, you all never contacted us, sir.
Did you comment to the court who you made the representations in front of? Did you let the court know that you made a representation that was inaccurate?
Again, that's why I put the comment in there to...
Did you inform the court about your misrepresentation?
No, I did not inform the court.
You relied on the defense and gave them the discretion whether they were going to clarify the record or not, correct?
But I provided the clarification, yes.
Mr. Brennan, could you move along, please?
As you sit here today, you don't really know how many communications you had with the defense before your last testimony, do you?
For trial
Attorney
one?
said he doesn't.
Yes, trial one.
I think it's all memorialized in the records and the emails that were produced.
The ones that were produced, but not things that were lost or destroyed or deleted, correct?
Again, there are records, even though the physical texts aren't there, there's certainly records of the calls, incoming, outgoing, as well as texts.
Do you remember when you testified in the voir dire, you were asked that before that morning when you walked into court, you had never met Attorney Jackson face to face?
Correct.
But you met him in court that day, right?
I believe I met him that day, yes.
You were asked whether or not you had ever discussed at trial now, after the voir dire, on June 24th, you were asked whether you ever discussed the substance of any of your testimony. Do you remember that?
Correct.
And so when you shared questions and answers and suggestions by email, was the statement under oath, you and I have never discussed the substance of your testimony. Is that still truthful?
We never discussed it, sir. Again, I sent it to him on my own behalf. There was no discussion that took place between Mr. Jackson about that.
You made comments after this was exchanged.
That was sent with the comments, sir.
And then you were asked whether you had ever been paid by the defense. You said no. You were later paid by the defense, weren't you?
ARCA did send an invoice afterwards, yes.
Did you talk to ARCA about that? About the billing in this case?
No.
You submitted your bill? Yes?
ARCA submitted the bill?
Yes.
Yes.
Mr. Klein, he was involved in the testing you did, wasn't he?
Yes.
Why is it that Mr. Klein didn't come in and join you? Who made that decision for trial?
Well, I think it was around, again, when we were talking about those June calls, I think that there was some discussion between Mr. Jackson and myself about Mr. Klein's involvement. And ultimately, he's also an accident reconstructionist, so it essentially would have been duplicative testimony. So we didn't feel, or Mr. Jackson, I don't think, felt it was necessary to call Mr. Klein as well.
That sounds like a little bit more than just scheduling, doesn't it?
I would describe that as logistics, sir.
Logistics. You had to describe what Mr. Klein's role was or wasn't in that report, didn't you?
Again, I went over his background as an accident reconstructionist, yes.
Well, so you only talked about background, and from that the decision was made not to call him, or did you talk about his role in your testing and in your opinions?
I didn't talk about his role, sir. I think ultimately the decision obviously was made by Mr. Jackson, not
I
me.
understand that, but I want to know what the conversation was that led to the decision not to call Mr. Klein. It wasn't simply logistics. What was the discussion you had?
Well, I told him that, again, we're both accident reconstructionists. Dr. Rentschler is a biomechanical engineer, so there would have been essentially duplicative testimony from both of us.
Well, your report's never very clear who did what. Would you agree with me that the report is a general report that has yours, Dr. Rentschler, and Dr. Klein's name on it? Would you agree with me?
All three of our names are on it, yes.
It doesn't distinguish who did what in that report, does it?
Correct, but I think it certainly was testified to at the voir dire in the time of trial.
Before the voir dire. When you spoke to the defense, did you explain to them what the different roles were for the different people that led to the decision not to call Mr. Klein?
Again, we went over our backgrounds, and I think from that you can deduce that.
I don't know what that means.
Well, if you're familiar with what an accident reconstructionist does and you're familiar with what a biomechanical engineer does, then you would be able to understand that.
Well, it would be easier to understand if you could just tell us what the conversation was. That's what I'm asking
But he
about.
doesn't remember.
I'll allow it.
When you had a conversation with the defense, did you tell them the role that Mr. Klein played in your investigation and in your conclusions?
Again, I told him that we are both accident reconstructionists.
Okay. And he chose you instead of Mr. Klein. Did you say there was a difference between you and Mr. Klein and what you did?
No, again, we were both a part of the testing. We were both a part of the review. So we had exactly the same role, essentially.
Did you tell him that?
No, I told him that we were both accident reconstructionists.
And you remember that's all you said about it?
Yes.
During the voir dire in the trial, did you get to watch any of the Commonwealth's experts?
No, I don't believe so.
Did you ever communicate with the defense about any questions and answers that could or should be asked?
No, but I will note that during the entirety of the first trial, the Department of Justice was closely watching it, and we had certainly a direct line of communication with them that they were giving us and providing us information about the trial as it was ongoing.
Did you ever communicate with the defense about questions and answers to ask?
I don't.
No, sir.
Did you ever see anybody's testimony at any time during
I
the first
think
trial?
I understand the point that they're
I
trying to
might have
make
seen
here.
a few
It's
news
just
clips,
ridiculous.
but I didn't watch any specifically, no.
Did you ever watch anybody's testimony? Did you ever watch any of the reconstruction's testimony?
No, sir.
Did you, after the trial, spend any private time with the defense?
No, I left town.
Okay. You didn't go to lunches or parties or anything like that?
No, I went straight to the airport.
And sir, is there any other communications that you've had with the defense that you didn't tell us about outside the texts and the phone calls and the signal calls, or any other communications that you can think of that you had with the defense?
No, sir. I've provided everything I have in my possession.
I have no further questions.
Mr. Leslie, do you have anything?
I sure do, Your Honor. Thank you.
Are we going to get to Dr. Rentschler today or not?
Well,
Is that
you know how
his
much time
issue?
Mr. Brennan's,
I'm
also,
just
I hope
asking
so.
you.
I hope so, Your Honor.
Okay.
May I approach the witness?
Yes.
Your Honor, may I approach the witness for the document?
Yes.
Thank you. Dr. Wolf, I am providing you with a document. Do you recognize it?
Yes.
What is it?
It is the order for production of records.
And is that an order from this court?
Yes, sir.
And is this the order that you were provided with in response to recent matters with regard to this court and what you should or should not be keeping in terms of records and what you should be producing with regard to records?
Yes.
Could you please read the, excuse me, at this time, Your Honor?
I have it in front of me.
Okay, well, I understand. So if Your Honor has it, I would like it to be part of the hearing, right?
We can mark it.
Yeah, that's exactly, thank you.
Make sure it's the same one.
Yeah.
I offered it into evidence, Your Honor.
Okay.
May I allow the witness to have that?
Yes.
please?
Trying to drink boba here.
Bear with me, Your Honor. Dr. Wolf, I realize that the court has a copy of this, but I'd like you to please read the first sentence in the indentation at the top after following.
Okay. All records within ARCA's or its owners, partners, employees, or representatives' possession, custody, or control in whatever format kept that reflect or in any way relate to work performed or contemplated and related in any way to billing, payment, compensation, and or reimbursement of any kind in connection with Commonwealth versus Karen Reed.
Did you, and to the best of your knowledge, everyone associated with ARCA comply completely with this order with regard to the records that are requested in it?
Yes, everything I had in my possession and that ARCA had in our possession, we produced.
Were you ever asked to answer questions or interrogatories in that order?
What
No.
I'd like to do is to go back in time with regard to your interactions with the United States Department of Justice in February of 2024. Was ARCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCA?
Well, let me just clarify something real quick. So the original case when it came in from the Department of Justice was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have from any time in 2024 any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
I've lost the tab. You all can still see it.
It's
still being
now
broadcast
go
on my thing.
to
But
your first interactions with the
all I
defense.
tried to do
As I
was
understand it,
fix it.
well, why don't you tell me what was the first date of your understanding of interactions with the defense?
Times like this that I hate Windows.
I believe it was sometime in mid
This kind
to
of
end
shit
of March
never
of
happens with
2024.
my Mac. But Mac is actually harder to stream with.
Again, that would have been over a month from when we issued our report to the Department of Justice.
Your Honor, may I approach the witness?
Yes.
Thank you. You're welcome. Your Honor, what I have is the entire production that ARCA made. I think it would ease in terms of the.
Sure, he can have it.
Thank you. Use that pursuant to the subject of the Honor's permission to answer any of my questions if you need to.
Okay.
Now, in March of 2024.
Hold on, people. We're closing some things.
Had your final report been issued, the final.
Stop sharing. Holy fuck. Hold on a second. We're gonna have to close everything. Holy shit. Jesus. That was absolutely fucking ridiculous. To have to do all that. Let's see what, oh man, Until the Law is way behind. Until the Law is way behind, Andrea. So let's go back to Andrea.
Substance of that report.
No, sir.
Did you have any discussions with any member of the defense before the voir dire testimony other than discussions about background and qualifications?
Other than, again, some logistics about how to get up here, where to go, things of that nature. But beyond that, no.
Other than logistics, how to get up here, when you were coming, background qualifications, did you have any discussions with any member of the defense of any kind with regard to the report to the U.S. Department of Justice?
No, sir.
Did the defense ever try to get you to improve or change any aspect of the report you had issued to the Department of Justice?
No.
At the time that ARCA was working for the United States Department of Justice, do you know whether ARCA could have been retained by any other party for any aspect related to the February 2024 report?
I'm not sure I understand your question.
In 2024, did the federal government prevent ARCA from entering into any contract with any other party with regard to your report of February of 2024?
So we were, again, because we were still under contract with the Department of Justice, we could not have any other formal agreements, contracts, retainers, anything of that nature, because we were still under contract with the Department of Justice.
Now let's go to the emails that were discussed with you starting with March 20, 2024, and then the subsequent email of March 22nd, 2024.
Okay.
Are you there, sir?
Yes, I think so.
Okay. Well, let's test to make sure. March 20, 2024, 10:49 a.m. from Alan Jackson to Daniel Wolf. Do you have that?
Yes.
And that email states in substance, thank you so much for taking the time to get on with the phone this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith along with your retainer as
we have to
required.
go through all of this.
As of March 20th, 2024,
I'm wondering what
was there any
doing, actually?
understanding that ARCA would be compensated by the defense for any aspect of current or future
how many
work?
people here?
No.
Was there any understanding or discussion that ARCA would receive any reward or payment or compensation for any contemplated work with the defense?
No.
Yes.
The discussions that you had with
I'm
Mr.
trying to figure out how many
Jackson
people she
that are
has
the subject
viewing
of this March
the
2024
live stream
email,
right now.
were there any inducements
Man,
to
59.
ARCA from the defense?
Let's see
No,
what
sir.
Nikki has going
After
on.
that email was received by you, did you have any understanding or expectation of any kind that ARCA would be compensated for any work associated
Oh my god,
with this case?
he doesn't even have 3,000. Holy crap.
What was briefly
So here's her
essence
5812
of that conversation that's discussed?
And you go to him.
Main line on March 20th, 2024 at 7 a.m. And that's Pacific Standard Time. So that would have been at 10 a.m. Eastern Time. So that call lasted for 39 minutes. And as I mentioned earlier with Mr. Brennan, I think that was a conversation about Alan trying to get in touch with me, letting us know that, hey, we've received your all's report as part of this federal investigation. You know, how can we go about utilizing you guys to come testify at trial? Can you guys come testify at trial? So, and then as I mentioned, I went over him
He's
with
looking like he's
our
having a hard
typical,
time.
Protocol for when a case comes in and a client wants to utilize us to
Staying
testify,
awake.
which is certainly outlined in that email. But obviously,
No, he's
given
just wearing a normal shirt.
very unique nature of this case, I had no idea if that was something that was okay, if it was
God.
allowed, what
Look
to
at
do.
that.
So subsequent to that email, I then reached out to the Department of Justice to get clarification on what the guidelines would be to move forward.
I'm going to come back to these emails, but I want to go right to the July invoice from ARCA
That's so
to
bad.
Worksman Jackson Firm. So can you locate that?
That's so bad.
Worksman Jackson Firm. So can you locate that? Is that in your production? It's the July invoice.
Yes.
Oh my gosh. I can't believe he's getting swamped by
I have it
Andrea.
located,
It's
yes.
crazy.
Did you
And then
ever have
if you
any
were to go
discussion
to
of any kind
to Emily G.
any
Baker
member
right now,
of the defense team about that
he would have
invoice
double those numbers at least.
before July 12th of 2024?
No,
just gonna
sir.
look at my
And I will
phone.
note, I am not a part of the invoicing or accounting at ARCA. When a bill goes out, how much it goes out for, who it goes to, I'm not a part of that at all.
For each and every entry on that invoice,
She has
did you
38,000
have
people
any
watching her right now.
understanding that the defense team, as you're making each of those entries, any understanding that the defense team was going to be paying for any of that work?
No, again, I think my boss wants to know what I'm doing with my time, right? What am I working on? Am I sitting there twiddling my thumbs, or am I working on a case? So that's the purpose of tracking time, sir.
So can you please describe how it is you enter time?
So
and
apparently
what it
Ricky
is,
has some new
what your
moderation
thought
rules.
process is as you're entering each of those time entries, not each one, but just collectively. How do you do it? Why do you do it? And how does that work in your firm?
So again, there's usually just a spreadsheet. Sometimes I'll write it down. Maybe my project manager will enter it. But ultimately, I keep track. If I've got an 8-9 hour day, right? I'm working on multiple cases that day, right? So I figure out, all right, did I have a telephone call? Did I work on a report for this long, right? So I keep track of my time in a spreadsheet so that ultimately, again, my boss and the accounting department knows what was Dr. Wolf doing on this day, this month.
Let's take the first entry on May 1st, 2024. You see that?
Yes.
Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
6/9/2024. Did you have any understanding when you made that entry that the defense was going to be paying for that time?
No.
For any entry on this invoice, did you have any understanding that the defense was going to be paying for this time?
No, sir.
When you're entering this time, if you had any understanding, was your understanding that this time was under the contract with the U.S. government?
Yes, because that's the project number that I put that time towards.
So at the time you're making each one of these entries on this entire invoice, what project number are you billing to, and which one do you have in mind at that time?
I don't recall it off the top of my head. I know it was the project number for the Department of Justice case, though.
Right. I'm sorry. I wasn't asking about the specific number,
Right.
but the ultimate client, when you're making each of these entries, who is it?
It's the Department of Justice.
Is it the defense in this case?
No, sir.
Did you ever have any discussion at all with any member of the defense team that this invoice was going to be sent to the defense?
No.
And for any entry on this invoice, did you ever have any belief that you were retained or engaged by the defense?
No, and as I mentioned earlier, again, the Department of Justice forbid that. So we could not be retained or in a contract with the defense.
I would like to now go back to the emails we were talking about. Specifically, we left off with the March 20, 2024. I want to now go to the March 22nd, 2024 email. I'm just going to shorthand that, refer to it as the pause email. What had happened between March 20th, 2024 and March 22nd, 2024?
Do you have the tab for that, the email that you're looking at? Sorry.
Tab 1, please.
Tab, okay.
We'll have to watch that video about his new
Right, so
travels
the
thing. Yes,
first
and really,
email that we were talking about on March
blame him.
20th, 2024 from Mr. Jackson to myself.
whether you're freeze,
It looks like the
advocate or
next
not, I
email
don't think
was
people would
from
be allowing
me
you
to
to
Mr.
say
Jackson
things about
2 days later, March 22nd, 2024 at 6 a.m. I sent in the email saying, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it." So what it sounds like, and from what I recall, is that between March 20th, 2024 and March 22nd, 2024, I had reached out to the U.S. Department of Justice and the U.S. Attorney's Office to get clarification on, again, moving forward with potentially testifying in the case.
And what did the United States Department of Justice tell you?
They said to wait basically until they internally figured it out.
So what was your conclusion from that conversation as to whether you could do any work on this case at that point?
At that point, I didn't even know if we were going to be allowed to testify. I know that from my conversation with the Department of Justice, I knew that there was a great deal of confusion on their end on whether or not, as expert witnesses involved in a federal investigation, if we would be even allowed to testify in the state matter. So their legal teams were trying to, I think, figure out what the road forward looked like.
And were you entering time under that U.S. contract matter in March of 2024?
Yes.
And do you know where that time was being billed to?
It would have been the same project number as the Department of Justice one.
That time was not, to your knowledge, being billed to the defense, was it?
No, again, there was through the entirety from, again, when the case from the Department of Justice came in 2023 till the trial concluded, all of the time was put to that one project number.
In March of 22nd of 2024, was any engagement letter sent to the defense?
No.
As of March 22nd, was there any retainer sent to the defense?
No, there was never a contract or retainer sent to the defense in 2024 at all.
So in terms of the discussion in the March 2024 email about engagement letter and retainers, were any of those ever sent?
No, we were not allowed.
And let's go back to that discussion of March 20th about engagement letter, retainer letter. Was that discussion where you were talking specifically about what you were going to do with the defense in terms of that relationship, or was it a general specific type discussion of the policies and billing procedures of ARCA?
Certainly, as is alluded to in the email, I prescribed to him our typical operating procedure for when a case comes in. But again, And there was, I remember part of that call, there was a great deal of confusion about what do we even do from here.
So as of March 22nd, 2024, can you just briefly describe whether there was any further activity at all by ARCA with regard to the defense?
No, I don't believe so. I don't think that anything, there was no communication, I don't think, until about a month later in April, after I had received that clarification.
Now let's go to April. Let's go to the voir dire hearing of April. When you sat on the stand under oath for the voir dire hearing, had there been any substantive conversations about the topics in the February report to the Department of Justice?
No, sir.
None at all?
None.
What briefly were the substance of the conversations you had with the defense team as of the moment you sat for the voir dire hearing in April of 2024?
Again, they were all scheduling, logistics. And when I look at these records here, you know, I see a phone call for 3 minutes, 5 minutes, 6 minutes, 6 minutes. There's a few that are for 1 minute, which I think, again, we were maybe just playing phone tag. But again, these calls are very short in nature. So again, it was just trying to figure out, I mean, obviously I know that this was a large trial, a lengthy trial, a lot of witnesses, things are fluid. So I know that Alan ultimately, I think, would reach out to me. And then, like I said, he would give me an idea. Hey, can you come this day, right? And then I would relay that to Dr. Rensselaer and say, yeah, that works for me. So that I would get back to Alan. So that's what those conversations were. Again, coordinating our testimony to appear for the voir dire.
It might appear to some that there were a number of conversations before in communications with the defense before you sat for the voir dire hearing. Were those conversations about logistics, background and qualifications, or did those conversations entail other topics?
No, it's what we've covered. Again, that March 20th, 2024 phone call, the very first one of 39 minutes, again, was us trying to figure out what the heck to do. The May 1st phone call, which was 40 minutes, again, was me going over my background, the work that I do, my qualifications, education. Other than that, there are very short phone calls, like I said, of 6 minutes, 3 minutes, 1 minute, 9 minutes, right? And again, that was in preparation to appear in terms of scheduling, logistics, timing for the voir dire.
At the voir dire hearing, do you recall the Commonwealth asking you any questions at all about whether you were being compensated by the defense?
I don't recall a single question by the Commonwealth on that, no.
Did the Commonwealth ask you any questions at that voir dire hearing about whether you had any substantive discussions with the defense about your February report to the United States Department of Justice?
I don't believe they asked, no.
Did the Commonwealth at that voir dire hearing ask you any questions about whether you had any promises or inducements from the defense before you sat down for that voir dire hearing?
No.
Waived. You didn't ask? You didn't ask something, you
now
waive
let's
it.
go to the next tab. With regard to the outlines that you were asked on direct examination by Attorney Brennan.
This is why they don't want to call him. Good one.
You've described this situation, well, you described how it is you viewed this situation. Have you ever been in this situation before where you're under contract with the federal government? There's rules of the road, so to speak, as what you can do, what you can't do, and then you've got a private defense team. Have you ever been in that situation before?
No, I think it's truly one of a kind, and I don't know that that'll ever happen again.
And have you ever been in a situation like that since?
We're probably hoping that's never going to happen again.
Did that cause you to have more or less communications with Mr. Jackson to
Oh,
figure
like,
out what
this
it
would be
is
totally
you were going
fine
to
if I
do or
never
not
had to
do.
go through this ever
Sure,
again.
yes.
In terms of your outlines that you sent to Mr. Jackson, did he ever broach in any way at all any idea of you sending him an outline?
He never asked, no.
Was there even any discussions that you might send an outline?
No, as I mentioned, it's something that for me is customary as I'm preparing internally for trial, right? I'm not going to come to trial, not review anything, not look over my notes, right? It's something that I do internally so that I can have an understanding how do I want to try to answer questions that might be posed to me such that I can have the jury understand how did I arrive at my opinions.
Was it important to you before you sent that email with those outlines, was it important to you that the jury got a fair and accurate presentation of the work you had performed in association with your February report?
Yes, I think that that's my job.
Was there any other motivation that you had in sending that outline in that email to Mr. Jackson other than making sure testimony was elicited that would make your perspective clear to the jury?
No, that was the only reason.
Were you trying to in any way favor the defense, give the defense any favor with regard to that trial?
Absolutely not.
What was your goal, both with sending the outline and the testimony at trial? What was your goal?
Again, as I mentioned, I think it's to help the jury understand the report, the analysis, what I did, what I reviewed.
Did the defense ever ask you to communicate to the jury about any aspect of your report in any way?
No, sir.
And did you, in fact, communicate to the jury what it is you intended to effectuate the goal that you just explicated?
I think so, yes.
And with regard to the comments that were in those outlines, what was your intention in putting in those comments?
Again, is to provide the jury, again, like for example, with the nighttime pedestrian statistic, right? It was to have them have an understanding that I wanted them to have an understanding that I do a lot of nighttime invisibility work, right? So therefore, I see a lot of pedestrian impacts. But again, I don't want them to take that statistic and say, well, we have this alleged incident, there was bad weather conditions, it was nighttime, therefore, we should give that more weight.
And is that desire of yours in your mind to help the defense more than to help the Commonwealth?
No, it's impartial. And I will note, I give numerous presentations, and I think slide 2 or 3 on presentations I give, it's going over that very same statistic. I would never shy or hide away from that statistic. And I believe I testified to that very statistic or that comment at the voir dire and in my trial testimony.
In terms of after you sent the emails with quals and issues pertaining to direct testimony, did you ever have any communication of any kind whatsoever with the defense team?
No, he didn't. Mr. Jackson didn't even respond. And I think when I sent the direct outline, it was Sunday evening before I hopped on a plane. And I think by the time I got into Boston, it was like 1 a.m. So I didn't even have a chance.
When you took the stand to testify the next day in that trial, had you had one word of a conversation with Mr. Jackson or any other member of the defense team about the substance of your upcoming testimony?
No, sir.
So you went and sat during that trial and gave testimony to the jury without ever having talked to a member of the defense team about the substance of your February 2024 report?
Correct.
Do you recall any member of the Commonwealth asking any questions at all during your trial testimony about whether you had been compensated by the defense?
No.
Do you recall the Commonwealth ever asking any questions at all whether you had communicated with any member of the defense with regard to your testimony while during your trial testimony?
I don't think that was asked. No.
Do you recall any questions from the Commonwealth about whether back in March or any other time you had been promised or induced by the defense? Do you remember any of those questions?
No.
Do you remember any questions by the Commonwealth at either the voir dire or the direct testimony about whether you had had conversations with the defense?
No.
Do you remember any questions of the Commonwealth at all before you sat down and after you sat down for trial about whether you had any text communications with any members of the defense?
No.
At the end of the trial, did you have any understanding whatsoever that ARCA was going to be compensated by the defense?
No.
At the end of the trial, did any member of the defense ever say to you, we're now going to compensate you for any of your work up to the time of your trial testimony?
No, and the records certainly reflect that I never
It's
spoke
just
to Mr.
really hard to
Jackson
say, in my
after the
opinion,
trial
what the
in
judge is
2024.
gonna do
There was no
here.
conversations
I
between
know
us.
Sean
Well,
thinks
let's go beyond
it.
Mr.
Ben's not going to have any
Let's
choice
go
but to
to
let her
any
testify.
human being. Did
I
you
just
have
don't know.
any discussions with any human being as to whether the defense was going to compensate you for any work, travel,
Any human being.
expenses, disbursements that you had or
Not your
incurred
dog. Did you tell
up
your
to
dog?
and through your trial testimony?
No.
And at that time, were you still under contract with the United States Department of Justice?
Yes.
Now let's proceed to December of 2024.
Oh God, a chronological presentation.
Were there any
Easy to understand.
conversations from the end of the trial until December of 2024, other than logistics? Well, was there any conversations of any kind? And please summarize briefly what they were, or texts.
The only communication that I had with the defense was Mr. Jackson. After I took the stand, I think that he sent me a text just thanking again for my time traveling up here. I said it was, it was great, and then we left, and that was it. I did not communicate with Mr. Jackson for the remainder of 2024.
Now let's go to recent communications. In 2025, did you have any communications with any member of the defense with regard to the potential? Well, let me go backwards. Let me go to the invoice. Let me go to the July invoice.
Okay.
How did you learn that that invoice was paid? If you learned at all, how did you learn that that invoice was paid?
I didn't learn. I didn't know that it was paid. I didn't even know it was sent.
Now let's go to this year. Did the defense approach ARCA to see if they might be able to testify in this trial that's currently pending?
Well, I think that the first communication of 2025 that happened between myself and Mr. Jackson was in February 13th of 2025. There was 2 calls, 25 minutes and 5 minutes, but it looks like just because there was a disconnect. So it was about a 30-minute call with him in February of this year.
And what was the substance of that call?
Well, I think back to that time frame, I became aware that I think that there was a motion or two regarding ARCA and potentially excluding our testimony for the upcoming trial. I also know that around that time, unfortunately, I ended up getting a significant amount of harassment through emails, and unfortunately even spread into my personal life where my wife was affected. They were posting pictures of my 4 kids all over the internet. So it was somewhat of a difficult time on my end. And I think what prompted me to reach out to Mr. Jackson was to figure out what's going on. Why is my family all over the internet? You know, why are they talking about me? Why am I getting all these hate emails? So it was, I think, a conversation to figure out, hey, you know, there's been several months that have passed. It looks like there's some motions pending against us. I'm getting a bunch of harassment. What's going on?
Do you have an understanding of why you were getting hate mails, hate emails, hate communications, your wife, your children? What did you conclude was the reason why you were receiving that?
I honestly don't know. I presume it was about comments made to me in court or that were represented about ARCA or myself.
So just so I'm clear on that, it was, you believe, regarding comments about ARCA and whether and what? Can you be a little more specific what your understanding was?
Well, I know that I received several emails that, you know, insinuated that I perjured myself on the stand. Like I said, and a lot of hateful comments just about me and the work that I do. So I received several emails with respect to that.
Sir, do you believe you have ever made an untruthful statement at all with regard to this matter?
No, sir.
Have you done your best to try to provide accurate and truthful information in this matter?
Yes.
Now to the last part, which is, did the defense contact you with regard to potential further work? I want to separate out now and move on from the work that you did with regard to the U.S. Department of Justice, your February 2024 report. We went all the way through the trial in that matter. We went to the end of 2024. Now I want to come to 2025 in a different subject matter, which is communications with the defense about doing further work for this trial.
Yes.
What was the nature of the communication? And so we can move through this rather quickly, but importantly, I want to get it complete and accurate. Just describe what the communications were on a timeline basis, subject matter, and with regard to your understanding of why you were contacted.
So subsequent to that February 13th call, as I mentioned, Mr. Jackson had indicated that he preferred to utilize Signal to communicate. So we exchanged a few messages and phone calls on that. Like I said, they were rather short.
I'm going to interrupt you for there a bit. Was there any discussion about the reason for Signal because the prosecution had been subpoenaing the phones of Mrs. and Dr. Reed, subpoenaing and seizing the phone of Miss Reed, that phones of defense attorneys had been requested to be looked at? Was there any understanding in your mind that there was a need to go to Signal to protect the defense and the integrity of the defense?
I didn't know that was happening, but like I said, I did not have a problem with communicating. To me, it was just another messaging app. I know people use all different types of applications, so I didn't have a problem with it.
Was there anything in your mind nefarious or underhanded about using Signal?
No.
And my understanding is this the first time you used a Signal app with regard to a matter professionally. Is that correct?
Correct, yes.
Did you get any understanding from communications with the defense that there was anything at all untoward about communicating through Signal?
No, I was not aware of any issue with using that communication.
Was there any communication whatsoever that you can recall on Signal that you have any concern about as you sit here today?
No.
And what were the majority of the communications, as best you recall, with the defense on Signal?
Well, as I described, I know that at that point, and like I said, it was primarily confined to a pretty short window in March, but Mr. Jackson had indicated that around that time, I think ARCA was being litigated by this court in terms of our involvement in the case. I know that they had started to, I think, receive discovery as it relates to the Commonwealth's accident reconstructionist and biomechanist. So they were, I think, interested in utilizing us potentially in the second trial. So I think that they had submitted a letter to the U.S. Attorney's Office to try to be able to work with us. I said that on my end, I could reach out to them because I hadn't heard from them in months. So I think it was around mid-March, I had reached out to the U.S. Attorney's Office to try to get my own clarification on whether or not we could move forward.
All right, so I want to stop you there. I apologize for interrupting you, sir. But what was the date that you reached out to the U.S. Department of Justice to see if you could participate in the second trial?
Probably around mid-March, maybe March 18th, March 15th.
Did you have an understanding at that time that the Commonwealth had retained an entirely new firm and expert in the area of accident reconstruction?
I think Mr. Jackson had indicated that there had been some material disclosed, but I think it was just a simple report or something of that nature at that point in time.
Was it a report, just like a page and a quarter or so of findings and conclusions and then a slide presentation? Is that what it was?
Yes, that sounds right.
Was any of that information
Are we ever just gonna like
helpful
get
or
to a
meaningful to you in your ability to respond to that and to determine what was done and what ARCA might want to do in response?
Well, certainly not the report. The report was very, very brief. The PowerPoint, somewhat hard to follow, but again, it really didn't provide a complete picture.
And in terms of scans, electronic data, etc., do you recall when you finally got that information?
Well, I think that would have been after the defense officially retained us on March 26th. I think that's when we received that information.
So in terms of the information that you received, those scans, etc., did that allow you to proceed with any meaningful work?
Well, it gave us, again, a better insight into the foundation or the basis for the analysis, yes.
Could you have proceeded with a contract with anybody, not just the defense, but anybody, with the level of information you had before you got the scans and the data?
I think it would be very difficult to do so.
Could you have even created a scope of work based upon that report and that PowerPoint presentation?
Most likely not, just because some of the areas that Dr. Rentschler and myself are particularly interested in are extremely vague in that report and PowerPoint.
Once you got the level of information that you have now, what is the ordinary time it would take in the regular course of ARCA's business
good record
to evaluate that information and prepare your own report, analysis, and finding? In the ordinary course, how much time would it take ARCA to do that?
Well, certainly for the nature of this case, as I mentioned, we were officially retained by the defense on March 26, 2025. As I mentioned, I myself just got word from the Department of Justice just a day or two, I think, prior to that we could move forward. So immediately, once Mr. Jackson, I indicated to him on the 26th that we did have authorization to move forward, he immediately asked that I send over, again, our typical procedure with the contract and retainer. And I think that same day, the 26th or the 27th, his office sent over, I believe, links to notices of discovery, I believe 1 through 62, which I think encompassed about 800 gigabytes worth of information and data.
How much in relative terms, 800 gigabytes? Is that a little data, medium amount of data, or a lot of data?
Voluminous, a lot of data. So we immediately started to review that. And again, I feel like maybe I speak for most experts. One thing we always want is more time, right? So in a case like this, I mean, ideally we would be talking months to be able to sift through all of that information, be able to do analysis, be able to do testing, be able to write a report, right? So I think certainly we are on the order of months, not weeks.
What did you do, however, if anything, to try to expedite the work and get it done as quickly as you could once you got the level of information you had from Aperture?
Certainly. So I certainly understood that the trial was imminent. So I worked as quickly as I could, along with Dr. Rentschler, to review that material, and certainly in parallel try to determine, okay, what testing do we need to do to effectively evaluate and potentially come up with opinions for this case.
Did you put other work aside at ARCA to work on this matter?
Absolutely, work and personal things.
And personal things. What did you put aside? Just one example.
So the other week, my wife and I, we celebrated our 10-year anniversary. So,
So it affected his personal life, I understand.
Okay, I'll move on, Your Honor. With regard to the work, you performed it on an expedited basis, as you said. You shortened the time period down as much as your firm possibly could. Is that correct?
correct.
You said you would like to have had more time, correct?
Correct, but I understood Your Honor's order, and I wanted to beat that deadline, so I worked as quickly as I could over the last week to ensure that, again, we could respect that deadline, and we completed our testing.
And with regard to the testing now that you've worked on, that you just described, does that testing relate to any previous work, or is it all in response to the new expert for the Commonwealth, Aperture, and the new information from Aperture that came in iterations through the month of February?
It would be in response to Dr. Welcher's work. Certainly, much of what was alluded to in his report and PowerPoint was not discussed in the first trial.
Could you have done any of the work you've been working on the past month or so? Could you have done any of that work without receiving the Aperture report and slides and scans?
No, I don't even know what we would be responding to then.
So you needed the Aperture information before you could even start working, correct?
Correct.
Do you have in mind, or does ARCA have in mind, any further testing that you need to do, or have you completed what ARCA needs to do with regard to fairly and properly responded to the new work of Aperture?
I think we're satisfied that we've completed that testing, yes.
And what, if any, more work do you contemplate that needs to be done from, as you sit here today, going forward?
Well, as I mentioned, all the testing is done, so I think the analysis and the report to follow, yes.
To use expert engineering type terms, is it QA/QCing the report? Is it putting all the information together in a compilation so everybody can understand what you've done and make clear your findings and conclusions? Is that what's left to do?
Yes, and I will note, obviously, as the court is aware, we've produced all of that raw test data, photographs, video, so it's all there. The basis and the foundation for what the report will lay out has all been provided to the court.
You got ahead of me, and thankfully, so there's my next question, which is, there's nothing that you have that you've done that hasn't already been produced to pursuant to the court's order. Is that correct?
No, I think that we've responded to the court's order, yes.
How long, on an expedited basis, well, let me ask you, in the ordinary course, how long would it take you to do this last part of your work, in the ordinary course?
Probably, again, it can vary. Maybe around a month would be fair.
However, it would take a month in the ordinary course. How quickly can you get that work done fairly?
I'm hoping, if it pleases the court, hopefully May 7th will work.
And so you believe everything would be completed by May 7th?
Correct.
Just over a week.
That's all I have at this point, Your Honor.
All right, Mr. Brennan.
Yeah, the only other thing he needs to do is show up and get yelled at about his emails, phone calls.
Doctor, you're suggesting that it's going to take until May 7th for you to complete your reports in this case?
And the analysis, yes.
Do you know when this trial started?
I think like a week or so ago.
You provided raw data last Friday,
Yes.
but you would agree you still have not provided any reports.
Correct.
You said if you were notified or received information, you could have your testing and opinions done within a month, correct?
Potentially. Again, it would also depend on when we got authorization from the Department of Justice, which, as I mentioned, was at the very end of March.
I understand that. We're going to talk about that separately. I'm talking specifically about how long it would take if you received the information. You said that you could have the testing and reports done in 1 month, correct?
I don't know. I said the testing, the reports, and everything.
Would it take longer than a month?
Ideally, I think it depends on what kind of a report that we're talking about. I think if it's something along the lines that Dr. Welcher produced, I think it could be pretty quick.
You said March 26th is when you received authorization, and you're going to have things done by May 7th. So that's a month and a week?
Sounds about right.
Okay. Do you know when the Commonwealth in this case turned over Dr. Welcher's information to the defense? Do you know?
I don't know, no.
Did you know that it was turned over in a report on January 30th?
Just the report?
Yes.
I didn't know that.
And
no.
the file in its entirety was turned over by February 5th? Did you know that?
Objection, Your Honor.
Do you know that?
I don't, Your Honor.
And if you had a month from February 5th to complete your testing report, you could have been done by March 5th or even the second week of March, couldn't you?
Presuming we had authorization, the defense had authorization from the Department of Justice as well as ARCA, yes.
Putting aside the authorization, I'm going to ask you about that. But just the time you need to test, if you knew or received the information by February 5th, you could have been done by March 5th or mid-March, couldn't you?
Potentially, yes.
Well, you're going to get it done that quickly now. So wouldn't that be an accurate guide to when you could have done it then?
It's certainly not ideal, but we certainly are working as quickly as we can.
I know it's not ideal, but isn't it the same time frame? Whatever it's going to take you from March 26th, you could have done from February 5th. True?
Again, I don't know the timeline in terms of what exactly was produced when from Dr. Welcher, so I'm not aware of that.
But I'm not asking about the timeline. I'm talking about the time needed to deal with this information. You said you could have done in around a month.
I think a month or more, yes.
So your contract with the federal government ended, ARCA's did, in June of 2024, didn't it?
I believe it was sometime last year, yes.
Do you know the Commonwealth notified the defense that they were going to have a new expert back in October of 2024?
No.
Are you aware of any effort by ARCA or the defense to try to facilitate an agreement that the defense could use ARCA as witnesses back in October or November of 2024?
No.
Are you aware of any efforts by the defense to try to notify the federal government to be able to use ARCA in December or January?
No.
And so as far as you knew, this came out of nowhere in March, that the defense wanted to use ARCA, or specifically you and Dr. Renchelier, in late March of 2025.
No, I think, again, it was, like I said, around February of 2025. I know that, like I said, when I spoke to Mr. Jackson, that he had indicated that the ARCA issue was being litigated. And I think that, like I said, there was, I think, multiple motions pending against us, and he didn't even know if he could move forward with us at that point in time.
Do you know why the defense waited until February 2025 to even seek permission from the federal government to retain you and Dr. Renchler so you could review the materials?
Objection, Your Honor.
Do you know? Do you happen to know that?
I don't know, no.
Next question.
You shared with us communications you had with the United States Attorney's Office. Were you receiving information in this case since the last trial from the defense or from the United States Attorney's Office?
This is just wild. I don't think she's going to let ARCA testify. I don't think she's going to let him in.
Information.
From the Department of Justice?
Anybody?
No, not until recently, no.
So you haven't seen any discovery until after February of 2025. Isn't that fair to say?
Correct.
Okay. Now, when you were involved in this case before trial last year, we talked about your communications and conversations with the defense. Was anybody giving you information as an intermediary? Was anybody updating you on the defense of the case or giving other information to you?
Yeah, I think I previously testified that the Department of Justice was closely watching the trial and providing us information.
What information were they providing you about the trial?
I think that they provided information regarding the some of the witnesses that had testified with respect to, I think, the reconstructionists, and I think some of the evidence.
So when the Department of Justice was giving you information during the trial about witnesses, what witnesses do you remember they were giving you information about?
The one that comes to mind was, and I don't even recall his name, it would have been the accident reconstructionist.
Is it a coincidence that when you were receiving information from the Department of Justice about particular witnesses testifying in this case, is it a coincidence that your phone calls and text messages are more frequent?
Is it a coincidence?
Yes.
I presume so.
Well, when you were receiving information from the Department of Justice about witness testimony in this case, was that part of the catalyst for you to either call or text the defense and ask questions?
No.
Did you ever share any of the information you received from the Department of Justice with the defense?
No.
When you were receiving information from the Department of Justice about witness testimony, that was before you testified, correct?
Correct.
And part of that, when they were giving you information, did they ever give you any live video?
No, it was just verbal communication.
And they were giving you updates and summaries of testimony?
I wouldn't say summaries. They just pointed out some key things I think that came out.
What were the key things they were talking about with the reconstructionist testimony? What were they telling you?
I think it was as it relates to the arm being outstretched, and I think some of the kinematics of the pedestrian. I also think there was some mention of potentially some DNA evidence.
I just can't decide if they've said anything
that's
going to save them and allow them to testify.
Part of your report, or to consider for your report, that you knew that there was DNA evidence because of the intermediary?
Because of the Department of Justice?
Yes.
Yes.
Did you know there was a sequestration order in this case that you were not supposed to consider or review other witnesses' testimony or information? Did you know that?
I was never made aware of that.
Nobody made you aware about a sequestration order in this case?
No.
But you did, in fact, receive information about other witnesses' testimony before you testified in this case in front of the jury, didn't you?
From the Department of Justice, yes.
What other witnesses were you advised about their testimony and issues in this case before your testimony in this case?
That's all I recall.
Well, you said it was more than one. You said some witnesses. Take a moment, think back. What other witnesses stand out that you were offered information from the Department of Justice about this case before you testified?
As I mentioned, I don't know which witness provided the DNA information, but I would presume that that's the other witness, yes.
So you heard information, you learned that there was information and testimony about DNA.
Yes.
And certainly when you took that information before you testified, you considered it when you testified, didn't you?
No, because again, our report was already solidified, so it didn't change my opinion in any way.
Well, not about whether it changed your opinion. You testified about DNA, didn't you?
I don't believe that I did, no.
I'm going to approach, if I may, Your Honor.
Okay.
This is your outline with your comments. You recognize this?
Yes.
I'd like to introduce that as an exhibit, please. Thank you.
Exhibit 3.
If that's 3, then
So as an expert, when you receive information, you need time to look at the raw data, don't you?
Wesley, make sure
Potentially,
yours
yes.
You
get
need
marked.
time to look at the report of another expert, don't you?
Potentially.
And then you got to consider whether or not you think that their testing is accurate. You can test their testing, can't you?
You can, yes.
And you can also generate new tests based on what you've read if you think that there is some explanation needed. Yes?
Perhaps, yes.
And then you can write a report.
Yes.
So it's fair to say when an expert introduces new information, testing materials, it takes about, if not at least a month to process through that information, vet it, and then consider your own testing.
Well, if they've already authored a report and done their own testing, that should be solidified and memorialized already.
Well, if there's new testing, if a new expert does something new and an expert wants to look at it, you would agree to sift through that much information and consider and vet it and then do independent testing. It could take over a month, couldn't it?
If it's necessary.
And it would be the expert that determines whether or not that was necessary, wouldn't it?
Sure.
And if your report is not due until May 7th, is that what you said, May 7th?
Yes.
May 7th. It could take an expert, if they wanted to do testing based on new testing that you provided, over a month, couldn't it?
It depends. I can't answer that.
When you wrote that initial report and you provided
But there's no
report,
surrebuttal.
How many pages was it? 10, 12 pages?
The original DOJ report?
The report that you produced in this case with your opinions, yes.
That sounds about right.
Okay. You never gave the raw data for that report, did you?
No, it was all protected.
It was all what?
It was protected as classified.
Have you been asked for it? Has there been a request made for all the raw data that formed the basis of your opinions, of those initial opinions?
My understanding from communication with the Department of Justice is that all communication and work product is protected and cannot be disclosed.
So that raw data that's necessary to you for your evaluation and your testing, that wasn't provided in this case, was it?
For the first trial?
Yes.
No.
And videos of the demonstration, you built like a potato cannon, right?
I'm sorry, what?
Potato cannon.
Smiling, thinking of his cannon.
If that's how you want to characterize it, sure.
Okay. Did you take videos of it when you were doing your demonstrations and tests?
Yes.
Never turned over those videos, did you?
Again, we're talking about trial one. As I mentioned, for trial two, let me finish.
Trial one. So
Okay.
no, I want you to focus on.
Okay. No, that
trial
was
one.
not produced. No.
Never turned over any of those videos, did you?
Again, we were not able to.
And was there any failed testing the first time around?
No.
In addition to videos, I'm sure you had other raw data, notes, photographs, right?
Yes.
And so when you look at a report, so for example, you saw Dr. Welch's report and you had access now to his file and data, correct?
Correct.
You reviewed that, didn't you?
Yes.
Because to be fair, you need to review not just the report, that's just someone's opinion. You need to review the raw data, don't you, to get an accurate understanding of an opinion?
Right, which we have already provided
Right,
in
so-
response to Dr. Welcher.
Without video and without the raw data, as an expert, there's no ability to really vet the reliability of your first experiments that led to your testimony in trial one, is there?
This is arguing against
I think you might be confused. Again, our role for this round.
I don't think
first-
I am.
Objection, Your Honor, you should be allowed to answer.
I don't think I'm confused. I'm talking about trial one.
Right.
You had a 12-page report. You provided no video, no raw
He
data.
just does what he
no
wants,
notes,
and she
correct?
doesn't
Correct.
take
But for
control.
this trial, sir, we are being asked to respond to Dr. Welcher.
That's
Okay.
not what I'm
We
asking
have
you.
provided everything that he would need to evaluate the testing that we have done.
That's not what I'm asking. What if he wants to evaluate the testing you did the first time? Are you going to come into court? Do you hope to testify about the opinions you gave the first time? About those 4 opinions?
I don't know what the defense's plan is for us. My understanding is that it's to evaluate and respond to Dr. Welcher.
All right, with that, I need to see counsel with that.
She has
Oh,
zero
boy.
control over this courtroom, and right
Well,
there,
she doesn't
right
want to
there,
have-
the old Dr. Wolf was just starting
She
to
doesn't
get the
wanna have
hang of
control
how
over
this
her
goes in her court. Oh,
That's the
you want me to be quiet? You're going to interrupt me? I'm just going to go ahead and keep talking, and maybe even a little bit louder. I'm just going to say what I want to say anyway. There's an objection. And before she can answer, Brennan just continues. She never cuts him off. She never gets control of the courtroom. She never rules on the objection. She never provides any guidance. He does what she wants and she's letting him. You know what this looks like? This looks like a spoiled toddler. This looks like a spoiled toddler or a spoiled dog, a dog that can't be controlled. They just do what they want. And the owner sits over there going, stop that. And the dog doesn't stop it. And what do? They say, stop it again. And the dog doesn't stop it. Why? Because the dog doesn't give a shit about what you say. Until you follow it up with some action, the dog's going to do what it wants to do. That's what I see going on in this courtroom. This is a dog that's figured out these words don't mean anything. These words mean nothing. I don't care about them. Because she's not going to control the courtroom.
Yeah, she doesn't care.
Well, we know that she's got an issue now because here we are at the end of the day and we have not gotten to Dr. Rentschler. No, of course we haven't. Of course we haven't. Notwithstanding Mr. Alessi being advised to move things along. How long is it going to take, Mr. Alessi? I don't know. Maybe it depends on how much time Mr. Brennan decides to waste on a lot of this stuff.
You're all set, and let's bring Dr. Rentschler in here, please.
They are going to bring him in.
Follow me, sir.
Thank you.
Yep, you got to give him a little. You're not hurting the dog. You're just getting the dog's attention. You better pay attention to me. Because I'm going to back up the command I'm giving you, and you're going to comply because you're the dog and I'm the owner.
Shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Dr. Rentschler, this is going to be very quick. Go ahead, Mr. Brennan. We just need his name.
Good afternoon, doctor.
Good afternoon.
Could you please state your name for the record and spell it?
Dr. Andrew John Rentschler, ANDREWJOHNRENTSCHLER.
You've testified before in this case?
I have, yes, sir.
In a last voir dire in a past trial?
That's correct.
Okay. Did you have conversations and communications with the defense before your last testimony?
I did, yes.
Did you use text messages to communicate?
I believe there was maybe one text message.
Okay. How about phone calls?
There was maybe one or two phone calls, I believe.
Okay. Would it be fair to say there was 6 text messages for you?
Yeah, I believe I sent one, and then there were 5 sent to me.
And were there 23 phone calls?
No, I don't believe so.
Have you looked at the records outlining the phone calls that supposedly you made to the defense?
I looked at the records from the defense, but then I looked at my own records, which indicate a different number, only 3 phone calls, I believe.
Okay, so the 23 phone calls that are summarized, you don't think you made those phone calls?
No, if you look at them, it's like 1 minute, 2 minute, 3 minute. And in that time period, according to my phone records, I have like a 21-minute phone call that encompasses most of that time.
Okay. Did you discuss with the defense before your testimony anything about this case?
I don't believe so, no.
When you say you don't believe so, do you remember speaking to them about this case at all?
I remember speaking about my qualifications and my background, and I believe that's it.
Did you ever use any other medium to have conversations with the defense other than text or emails or phone calls?
No, sir.
Did you ever communicate with them on Signal?
No, sir.
Why not?
There was no reason to.
As an expert, when you communicate with clients, there's no concern about having it in writing, is there?
So when I...
Keeping a record, whether it's a phone call or a text message or an email, there's no concerns when you're dealing with clients having a record of that, is there?
Well, I don't believe that ARC has any specific policy for that, no, sir.
Mm-hmm. Did you keep track of your hours prior to your testimony?
I did, yes.
And before you testified, did you have conversations with people from the Department of Justice about this case?
Yes, I did.
Did they inform you about witness testimony?
They did inform me, yes, about testimony and situations and events that came forth in the trial that I was not aware of.
Who decided whether it was going to be an issue worthy of talking about before trial?
With the DOJ, you mean? Yeah. Well, certainly that would have been up to the DOJ. I mean, I would have had conversations with them. I don't believe that I asked or requested anything, but they were called to update us about what was going on.
Do you know why they were calling and raising certain issues with you?
Why don't they ask these questions to the DOJ
themselves?
Bring in a representative of the DOJ and ask them these questions.
It helped prepare you for your trial testimony, didn't it?
It would certainly help prepare me to understand what was going on during the trial, yes.
Do you know there was
who made what decision when?
That there was supposed to be no discussion of testimony and issues that were occurring in the courtroom before you testified?
I'm going to allow it. Were you aware of that, sir?
No, I was not.
Okay.
After you testified, before you testified, did you get a chance to meet anybody from the defense?
Just when I came at court, I think for the voir dire is the first time I met anybody.
Did you just spend time with the defendant and the defense after your testimony?
Well, after my testimony at trial on the 24th, yes, I was provided a ride back to the airport, and I believe I was the last witness. So before my ride to the airport, they said, there's a lunch next door. We need to get somebody else to take to the airport. Come over have lunch. I had lunch, stood in the corner, and then got a ride back to the airport.
Spend time with the defendant and her family?
Oh, they were certainly there.
Did you talk to them?
Well, they talked to me. As I said, I ate my lunch, and then I actually went and stood in the corner, and then I believe some people came over to talk to me and approach me.
So you spent some time with them?
Certainly, yes.
Okay. And, sir, I understand the report is not going to be ready until May 7th or after?
I believe currently that's what the estimated deadline is, yes.
And so in evaluating Dr. Welch's materials, you want to look at the raw data, the conclusions, the findings, the PowerPoint, all the materials, right?
Yes, you'd like to review all the materials before coming up with an
And then you
opinion.
make a decision on what you think is appropriate to contest or maybe agree with, and then do your own test if necessary, correct?
To be able to respond to what those opinions and allegations are, yes, sir.
And it's taken you at least a month to fairly do that, hasn't it?
Well, I believe that's what we've had, a month. I don't know if it's taken us a month. That's basically all we've had up to this point to do that.
And it's still not done.
No, not yet. That's correct, sir.
All right. Is that it, Mr. Brennan?
That's it, thank you.
All right. Can you get that report and everything completed before the 7th? If I order you to do so?
If you order me to do so, I mean, I could certainly try and expedite it.
All right. I appreciate that. Thank you very much. You're all set, sir.
Thank you, Your Honor.
All right. I'm going to see counsel at sidebar for 1 minute.
Back to sidebar. Well, guys, is that going to be the hook that Judge Cannoni needs? There's just a couple of issues here that if she wants to sink her teeth in and say, nope, I'm going to find a violation, so I'm going to take it out on the ARCA witnesses and not let them testify. I think there's two areas that she can sink her teeth into. One of them is this sequestration order.
Right. That's it. Thank you.
All rise to the court, please.
Guess we're done. I guess we're done because the jury is already out for the day. We'll see. I'll leave it on the fan until they kill the stream. So the sequestration order, it is the person who is calling a witness, it is your obligation to inform them of any pretrial rulings that limit their testimony or that limit their behavior. And so, for example, if you're not supposed to mention things like, oh, I don't know, the harassment that you've received from other witnesses and so forth, if you're not supposed to mention that there was a previous trial, just throwing these out as hypothetical examples, it is the responsibility of the person who is calling that witness to make sure the witness knows this is the limitation on you. And so similarly with the sequestration order, the person who's calling the witness is the one who has the obligation of making sure that they know you're not supposed to see anything, attend anything, and so forth. So I see this as something that she can potentially jump on. There's no sound, but there's closed captioning coming up on the screen. I don't know what's going on. That's something she can jump on. Oh, defense, you never informed them of a sequestration order. That's a violation. That's a violation. They violated the sequestration order. There must be a sanction. The other one that I see is with Dr. Wolf, the preparation of this outline and the comments. And the reason why I see this, okay, they've ended the stream. So I think we are, in fact, done for the day. She has a little bit of discretion in the context of deciding a motion, a pretrial motion, although we're in the middle of trials. This is still a pretrial motion. She has some discretion to make preliminary factual determinations to the extent that it's necessary to be able to decide the issue that's presented. And she can rely a lot on her own credibility determinations. It's one of the ways that judges who have been around the block a few times and want to insulate their decision-making from further appellate review, what do? They ground it in their determination of who is credible and who isn't. sound a little bit like that opinion from Justice Nicol way back in the UK trial. Johnny Depp versus the Sun. It's exactly what he did. It's exactly what he did. He grounded his decision about what happened in the case based on his credibility determinations, where, for example, he found Kevin Murphy wasn't credible because he made a statement against interest, which normally makes it more credible, but in that case it didn't. The video recordings, the audio recordings, those weren't credible because they weren't under oath. You remember all that? Yeah, and that's what insulated it from further review. When Johnny Depp tried to appeal that, and it went up to the Court of Appeals, and they're saying this is completely contrary to the evidence at trial. And the Court of Appeal says, well, but we have to defer to those credibility determinations that the trial court made, because after all, we weren't sitting there in court. We didn't get to see it as it unfolded. Do you guys think she would dare to find Dr. Daniel Wolf not credible on his explanation?
Oh, I think she would.
If she wants to keep him out. If she wants to keep him out, she'll say his testimony to the jury, if she wants to, his testimony to the jury about not having any discussion with the defense about his testimony, that was not true because he had sent that text. And so to the extent that he's testifying, well, he didn't understand it that way because the text was never responded to, or the email was never responded to. He never even got any acknowledgement from AJ about it. She'll say that lacks credibility. And he was trying to help the defense. If she wants to rule against ARCA, mark that. Put that marker down. That's my prediction. That's my prediction about what she would rely on. And then she can rely on that to, call into question the whole thing. The whole thing with the time, the texts and the explanation for it, the volume of them and so forth. They say Dr. Wolf primarily has said this is all scheduling and logistics. She can say, I found you lacked credibility in that other thing, so I don't really believe any of it. Just a little pathway here, if that's the direction she's inclined to go. I suspect that might be how it shows up in her ruling. We'll see.
Yeah, I don't think it's good.
We'll see.
I think
but
it's not good for Karen.
It
I don't
appears to
think.
me from her comments before, she is looking for a reason to try to sanction them, because otherwise, Hank getting mad and throwing accusations around that he doesn't seem to have much of a basis for. We still got no substantiation of any kind that there is anything improper here, that the defense ever manipulated their testimony in any way. We already knew that because we already knew what they testified to, and we already knew it was consistent with their report. So we already know that they didn't change anything. But yeah, what'd you guys think of that? What'd you guys think of that with Mr. Brennan? What'd you think about his manner of testifying? We know that's kind of what he's trying to do. His manner of questioning. Here's another marker I'll lay down. Mark this right here. He'll never do that in front of the jury. He'll never do it in front of the jury. Even if ARCA is allowed to testify, watch it change. Watch him be sweet as pie to ARCA. Watch it. He'll never do that in front of the jury because he knows he looks like an asshole. He knows he is being an asshole. He knows that's the whole point. So he'll never do that in front of the jury. He's only doing it with Bev because she lets him get away with it. Because he does what he wants and she doesn't correct him. She doesn't enforce any rules against him. She doesn't enforce any boundaries against him. He continues to do what she wants and what he wants, and she allows it. And that's going to continue to happen. But no, he will not make snarky asides. 4 times. 4 times she tells him, stop with the comments. Was there any consequence at any point? No. So what did he keep doing? He kept making comments. Even after that fourth time, he still, still making his little editorialized injections. So, yeah, big signal right there this afternoon. She's not controlling the court. Hank Brennan's going to run the court. He's going to run how things go. If I'm the defense, I am processing this right now, and we are preparing a plan B. I'm potentially, letting my witnesses know. Wait till the judge shuts you up, because if she doesn't stop you and shut you up, nobody's going to, and nobody has to. He starts talking, go ahead and continue. Make the judge make you stop. I might be making a strategic note. I object. Hank Brennan continues to talk. I'm going to continue to push the point. Your Honor, there's an objection pending. I'm not going to just let it keep going. Might be making little notes of these things after that little performance today. Well, now I guess we wait. If you can get it done, if I order you, can you get it done before May 7th? You just made them take a whole day to be here for this. And they're asking for a week and a day, a week and 2 days to do what they would normally do in a month, and to do what the Commonwealth's expert did between October and March. But he might need to test their testing or do new testing. Why? If his original testing is good. If his original testing is good, wouldn't you just stand on business? Why would you need to retest the defense's test or do new tests? Surely you did a thorough and complete job the first time. So again, if your opinion needs to be that reactive to how the defense responds to it, well, maybe you just didn't start with a very good opinion. Maybe it's that. Wild, guys. Wild. I was impressed with how Dr. Wolf held up under that kind of treatment. Clearly a little bit baffled about why he's being subjected to this level of disrespect and why it's being allowed, why he's not getting to explain his answers and so forth. But he didn't once lose his cool, not a single time. Very professional witness. I'm impressed with it. Not a baitable guy. So guys, with that, we are done for the day. So I will go ahead and take that off, and let's start getting into your questions and comments. See where we left off. Z, RG and TB buy and test same model in iOS. Why not Ian Whiffen? I don't know. Yeah, good question. Why didn't you test this in the same, using the same same thing? Why did you do this analysis on an old iOS and then extrapolate that to a new iOS that's doing different things, but assume that it's, overall still functioning the same? I don't have an explanation for that. But yeah, generally, if you're doing testing, you compare apples to apples. It does nobody any good for you to point out that an apple is different from an orange. We all know that. My Mini 67. Andrea, I could write an essay on GPS tracking. I would love to read it. I would love to read it. There's so much out there. Location services on your phone means that, you know, any app on your phone that uses location data can get your location data from all the different sources, GPS, the tower triangulation, all that stuff. Something, my Mini 67, if you're interested in filling me in, that I'd like to know a little bit more about, is that it's my understanding, and correct me if I'm wrong, that your phone will continue to collect location data even if you have location services off, because it keeps it for purposes of emergency response. If you get lost in the woods and they need to track you down, they have that information available, even if you have location information turned off in your phone. That's my understanding. I could be wrong. So if you got information about that, I would definitely love to know what you think. Greg Cagle, perfect timing. Finish with Commonwealth half a day, rest of day voir dire. Defense gets night to formulate cross for tomorrow. Lots of witnesses' opinions to highlight. Yeah, they get to finish with Mr. Whiffen tomorrow. I don't think they were done, right? I don't think they were done. He was moving into a new area. It was a good time to take a break, so they took the break, and then we had to spend the afternoon on the voir dire. So, yeah, he's got time over the night if he needs it. He may not need it. This man came in, Mr. Alessi. He came in prepared. That's like his MO. Oh, there's something you may need to rely on. Here it all is in a binder. I've got it all. I've got everything. You already have that order? I don't care. I want to make sure that the witness knows what you're looking at. He didn't get his copy of the order marked and admitted as evidence, but I don't think it matters, because all he cared about was that operative sentence about what exactly ARCA was being directed to do, and they were being directed to produce documents. And that's what they did. He wasn't asked to provide an explanation for anything that they don't have documentation of. That is literally your job, Mr. Brennan, to ask him. There's any other communications that aren't reflected in a record that was produced, and you did. And so now we know they talked on Signal for a short time in March. But yeah, I don't know that he'll need the extra time to figure out where he's going with Mr. Whiffen, but he certainly has it if he wants to review what he's already prepared, reviewed what Mr. Whiffen said today, see if there's any other holes he wants to attack. My Mini 67, Safari tabs are quantum. You don't know what's there until you look. It's Schrodinger's tab. Right? No idea. No idea what the tab is or has on it or is about or what time until you need an answer. and then it can be what you need. Brent Mack, Andrea, can the A team get at Be in Trouble 31 2 videos in as a demonstrative showing broken arm from 25-mile-an-hour crash and no salt dust in lens? No, they can't. He's not an expert that's been disclosed, or his basis. Nothing like that has been produced. So they can't rely on it. It's not a demonstrative. A demonstrative is something that you use as an aid to your own testimony. And so, like, for example, if I'm going to be telling you about where I went, where certain events happened, then we might use a map as a demonstrative, or I might draw like a layout. I went to this room, and then here's how it looks when you go down the hall. Things like that. Those are demonstratives. They're there to aid your testimony. As far as we know, the defense doesn't have anybody testifying to this. Now, I would love it, of course, if ARCA, part of what they were doing, their testing, was recreating something like this. But if that's the case, it would be ARCA's own opinions and their own testing that they did, that they would show the jury. If there were any demonstratives that would assist them with that, it would, more than likely be their own work. So no, Be in Trouble 31, his videos are fantastic, but they are not going to be seen by the jury. I really did enjoy them, man. That one showing the way that the light moved with the diffuser, like the way the light actually appears in the tail light when it's busted up like this and then is turned back on. Like, well, how did nobody ever think about that? Why don't we break it and turn it back on and see what it looks like? And then we can compare that to what we see on all of these nighttime videos with this tail light lit up. Is that how it would look if it was in the condition that it was in when the Commonwealth had it? Sure doesn't look like it to me. Ah, it was such a good idea. Lady FDD, Hank avoid calling the McAlberts to force the defense to do it. Obviously trying to avoid the jury hearing them before tech info. Will Alessi kick his ass on cross? I don't know if they're going to call the McAlberts or not. So according to Turtle Boy, Jen McCabe is up tomorrow. So they won't be ignoring the Alberts. The Alberts are a pretty important part of the story. The Alberts are an important part of the story, if only because they have to deny that John ever went inside. They have to deny that John ever went inside for this theory to work. If they never get on the stand, and I'm the defense attorney, I might be thinking to myself, well, I'm not calling him either, because I can put John in the house without them coming in and denying it. I can point to this location data. I can point to, look, the steps. I can point to, look, even their own measurement has the location, including the corner of the house, you know, and then it gets all inaccurate, and he's moving all over the front lawn. I might not even call him if the Commonwealth doesn't, because they have to deny he came in the house. Otherwise, the defense theory starts to make a little bit more sense. Oh, and that's why Lucky didn't see him at 2 o'clock, at 3 o'clock. So no, I think they're just, this is kind of what I started at the beginning. It's primacy and recency. You bury the stuff in the middle of your case that you want the jury to remember the least. The stuff you want to stick out, you put at the beginning and you put at the end. So what does he want him to remember? I hit him, I hit him, I hit him. That's what he started off with Timothy Nuttall. Now, the fact that Timothy Nuttall was, decimated as far as his memory, it's also the first cross they're going to remember. So that might not have been the best gamble, but as an earnest witness goes, he delivered. He's the true believer of the I hit him, I hit him. He really does believe. I think that. He really does believe he heard it. He believes it so much that he remembers it a little bit better every single time. Gets a little bit more detail each time. Just unfortunately, those details don't add up with what you can see on the actual video. Mike from Providence. Karen connected to John's Wi-Fi at 12:36, and Apple data shows John's last movement at 12:32. No chance she could make it to his house in 4 minutes. Yeah. Yeah, I mean that's part of the issue here. We heard that at the last trial that it was like a 6 to 8 minute drive to Meadows, and that's like under normal driving conditions, and this is the middle of a storm. So what excuse might we get from the Commonwealth? Well, she was angry, so she sped. She drove really fast. She drove recklessly. Maybe she ran some red lights. But we don't have any type of black box data. You're like driving extra fast in a storm. Don't you think you're probably gonna like skid? Have to hit your brakes hard. Yeah. Take a corner too fast.
Let's look at some videos here that have been clipped in
slick
Nicholas
snow
Locata.
has just started to accumulate. Probably gonna fishtail a little bit. Does that seem plausible? I mean, I don't know. I don't know what they're gonna try to come up with. But Karen connect.
Wallace Eclipse. I believe it's the one that has what I'm looking for.
Hey, Nick, this is Coach SCOTT. While April's under your desk, tell her to plug in your Ethernet thingy cord.
I have not seen April since January. That's
the quality for some reason on my thing is bad.
And I don't have any contact with her or anything like that. She is moving on with her life, and people should leave her alone because she's clearly gone from the internet. So that being said,
I don't know why it's so.
Hey, Nick, this is Coach SCOTT. While April's under your desk, tell her to plug in your Ethernet thingy cord.
I have not seen April since January. That's very many months. Confusion. And I don't have any contact with her or anything like that. She is moving on with her life, and people should leave her alone because she's clearly gone from the internet. So that being said, people who aren't on the internet shouldn't be the target of anything. And I know we've had a little moderating going on in the chat.
Huh. I don't know what's going on. I want to see it's like this.
There's some conflict, I guess, over what is appropriate levels of moderation.
I don't know why.
I've been kind of toying around this idea, and I think it's a good time. I've been back for a week. People have had a week to say whatever nasty shit they want, and it has gone largely unpunished or undealt with. I don't really care what people say about me. I'm on the internet. I'm a public person. I've made bunches of bad choices. So go ahead and make fun of me all you want. It doesn't bother me. I don't care. Guys, when the government takes your kids away, the internet doesn't really bother you. Like when they say, aha, you're a drug addict or whatever. It's like, okay, fine. You can't take my kids away. So that's, I guess, say that I'm not threatened by that statement. That said, I mean, I've probably,
I don't know for sure what it is they may or may not be saying about his kids in chat, but I mean, some people are mad at it. But who wouldn't say that? Who wouldn't be like, say what you want about me. I'm not gonna let you go on about my kids. That'll be blocked.
let some things go that should not be let go. And I'm going to follow Andrew Bronca's lead on this. If you have disrespectful things to say about Lady Rackets or my children, some of the stuff that's said in the chat today has been well beyond what is acceptable in any circles. If you said that to me in public, we would have a different discussion. That said, yeah, I don't care if my mods ban you after you suggest what people are suggesting about my children. I don't have sympathy for you. You can go free speak wherever you want. But you can, again, say whatever you want about me, my choices. I'm the one out here dealing with it. You talk about my wife and kids like this more, and I guess we'll just keep removing you, because I know you'll keep making new accounts. It's fine. But it'll become less and less profitable for you, I suppose, at some point. So yeah, I don't care or have any fucking sympathy for you at all. In fact, if your house caught on fire, I'd probably pour gas on it. Anyway, that being said, go shut up a different chat if you don't like it.
I mean, I don't know.
And then
how I can blame them.
They had to back off of the. Remember, like, we playfully beat the shit out of Will last week because Will has completely fallen apart. He went on the 30 viewer at a time Cripple Boy show. Not you.
Hey, I have way more than 30 viewers at a time, and I did not have Will on my show.
I just realized.
Get two things clear. It is closer to 60.
Yeah, see, this one looks fine. I don't know what's wrong
I didn't have Will on my show.
Oh, sorry. You're kicking Quad's ass.
Oh, wow.
Yeah. Literally,
everyone else in the world.
Literally 2 no-legged men in an ass-kicking contest. That's amazing.
And I'm winning.
So Will was on there, and he had to back down on because his whole cope has been, oh, Aaron contacted my boss. It's like, why would Aaron contact your boss, but also warn you, like, hey, dude, motherfuckers are telling me they're going to contact your work. Back out of this shit because you don't want these retards with you. Like,
right?
You'd never warn him. So I went over my emails, and Chad Buzamak, by the way, has still not posted his public apology, even though he knows I didn't do that. So their big cope, Will's big cope, is now he went on there and he went, well, I'm not sure if it's Aaron, but I want to think it was. It's like, dude, just stop. Because he was on that shit where he was like, oh, I know it's Aaron. I know it's Aaron. Mm-hmm. And then he realized he didn't have proof. He didn't have shit to show. So he wanted, he was just trying to cope his way out of his L. And then the Onion Boys were going, oh, no, maybe it wasn't Aaron, but, like, he's got plausible deniability, like it was SP doing it on his behalf. And it's like, could you be more fan fiction-y? Like, who wants less to do with this shit than my girl does? She thinks this stuff is retarded. She doesn't want anything to do with this. So now their whole cope has been, oh, Aaron's been flaunting that it wasn't him. Aaron's been kind of taking us to the woodshed. We got to make something up. Also, they're used to Rekieta lying to them, and they know how Rekieta lies, which is like, he lies, and then when the truth comes out, he goes, well, I didn't say it wasn't this. And so, like, they're trying to, like, put that whole thing together, and it's not working. So I don't know which L you're talking about, L Train, but there were a few of them. But it's like, dude, tie your wagons to Nick and Will and see what happens to you. Like, that ain't me kicking your ass. That's you kicking your own ass. Like,
nobody made you take this cell. You know what you guys are doing? You're becoming a cell phone. You guys are becoming this.
And Nick also lost his co-host. His co-host has had it with his shit. He already quit 1 weekend.
Ooh.
And he's the lowest rated LawTube streamer, and he is getting crushed by Steel Toe in views per subscriber. It's not looking good. I don't know. He's like an hour and a half late for his stream. It ain't looking solid. Nova says Will is relegated to interviewing Pat Dixon. Numero Uno says, can we squash this Will Heron beef somehow? It's unseemly to beef with a Clipper. I'm not beefing with a Clipper. I'm beefing with Will Heron, the donkey-toothed weatherman. It's totally different. You know what was really depressing today? And I'm so happy for him, and I'm glad he did great numbers today. But the rate we were cruising at until Meme went live with a Rekieta stream.
Yeah.
It's like we got up to 725 at 7 o'clock, and we usually peak out at about 8 with about 800. And it's like, I was looking at it today, and I'm like, dude, we might push 9. Like, there's a chance we push 9 today. And then I got a notification on my phone, and it said Meme Copium went live, and it said Nick Rekieta falling apart. I'm like, oh, shit. I knew
he had a very interesting week, so I get why people.
I knew right away. Did you see what he did with Josh from Kiwi Farms?
No.
He texted Josh.
I just know that he had a co-host that didn't make it a week. Like after a week, they were out.
Well, he texted Josh from Kiwi Farms, and he told him that. He said you have to take down that address from MN Public Records, that address that he posted, that was April's address that they said they'd seen Nick's car at in Wilmer. And Nick was texting him like, you have to take that down. You have to take that down. You have to take that down. And Josh wrote back to him, stop being unfaithful, you piece of shit. And he just smoked him. So, like, Nick does this shit where MN Public Records drops something, and then Nick confirms it, where he could have just shut the up and not said anything.
Pay no attention, pay no mind.
And then he shit talks Josh, he shit talks Kiwi Farms, and then he expects him to do something for him. It's like,
why wouldn't you? Why wouldn't you help out the people saying shit?
It's like you've got to be the dumbest mother in the world. You've got to be brain damaged. And then people are covering the fact that he started in like the 3,000s when he came back. Now he's at 2,000. His views are crashing. And it's in the most popular trial there is. I mean, Emily Baker's doing 30 to 40,000 people at a time, and he's barely getting to 2.
Yeah, but he's also not starting consistently. Like, his stream will start an hour late, and it's more of the same stuff.
So anyway, to update you on the whole thing, he texted Josh from Kiwi Farms to try and get that taken down, and he said no, so he confirmed it. Then Kurt of Uncivil Law, who Nick has been an absolute piece of shit to, is beating Nick in views. He was on this weekend doing like 60% more views than Nick was while the trial wasn't even on, which is huge. So good for him. Nick is now down to comparing himself to our numbers, which is a bad idea too, because we're not covering a trial. So 800 versus 2,000, a 13,500 subscriber channel versus a 455,000 subscriber channel.
A lot different.
Sorry, buddy, we're winning. Views per subscriber, we're kicking your ass. Basically, if you gave if we swapped channels, we'd be doing more numbers than you're doing. You'd do less numbers than we're doing. That's a fact, Jack. Sorry. I think that's the whole update. Oh, and Sean, potentially criminal, he went on a show this weekend and said MN Public Records has 70 more documents ready to drop.
What we can't figure out is
So
when
it's
exactly
it's
they
never
plan to release them.
It's never.
Is he
gonna
waiting for
end.
you? Is
And then
he or she
that
waiting for evening
co-host, that other
streams?
lawyer guy, the only lawyer
Does
that was
Nick
on
know-
stream
or
with Nick, because
Nick
Nick's
does-
not one anymore. He
Yeah.
quit.
Does the criminal
he
know
tapped
this
out on Nick. He's like, I'm done.
because
He's covering a different trial now. He said he was going
He
to cover this
knows
Karen Reed thing until it was over. He
MN
told
Public
Nick, I'll see
Records
you on
is-
Monday. And then this weekend, he just went, I got to get the away from this guy. He's
told him to
toxic as hell.
lie? You know,
So,
at least
it's
not
all
knowingly
going to
misleading
shit
anyone.
for old
No
Nicky
reason to
boy.
believe
Couldn't
that he's
happen to a nicer guy.
Knowingly misleading anyone. So
It's a shame.
Brian writes,
not clear how he knows
Oh,
that.
by the way, congratulations to Ethan Ralph for not being dead. That's big. Big for Ethan Ralph. Redbird with $1 says legal is also
I thought
covering
for sure it would
Johnny
turn
and
out
new
they threw him in
charges.
jail.
You didn't have a chance. Oh, shit, really? Wow, so we got into the 700s, which is a bad day for us typically, but we got there while Meme Copium was doing a Ricada stream and Legal Mindset was doing a Johnny Somali stream. Now I don't feel bad at all.
Yeah.
That's pretty good.
Actually,
Thanks, guys.
That's actually, no, that's like finding out you've been fighting the whole time with one hand behind your back. Pretty good mood.
Bigot on Socialist Media said, what was the name of that lawyer that was on with Nick? I can't remember. I feel bad for the guy that he had to tap out because it was all so toxic for him.
I don't know. I just I know someone was talking about the law tube situation, just being like, yeah, Nick Ricada's co-host is done after a week. Didn't even last 2 weeks with him.
I just
so it was
wondered if
not a
we
good
have
sign.
anything from either of them saying specifically why he did it. I'm gonna ask.
I'm sorry, I'm just getting wind of this.
I'm gonna ask here in the Discord. Does anyone know if either Nick or Bronca said why they aren't streaming together publicly? Publicly on today's stream. Let's see if there was something else.
And then,
Hey, Nick, this is Coach SCOTT. While
Let's go to Stalin. Not sure if I'm typing this right. See, it's weird. I have a hard time getting everyone that I follow to show up. So STALLYN Stalin 16, Stalin 19. Let's see if he's... Well, it's kind of looking like him and... Seems like they got the same thing here. Huh. It's weird. Hold on a second. His clip is a little bit longer than what she had. Okay, well, you guys, this is all that we really have for today. I need to do some walking, get a little bit of exercise, get some fresh air. But I will catch you all later. Bye.